Good morning.
You, Raymond Bloom.
Yes, sir.
Mr. Bloom, the allegation is that on May 2nd, that you did possess methamphetamine, which is a felony punishable by up to 10 years imprisonment. Count 2 did carry a dangerous weapon to a pistol. Count 3 did resist or obstruct a police officer. And count 4, you did possess a firearm during the commission of a felony. That's the one that carries a mandatory minimum 2-year prison sentence, preceding and consecutive to any other charge. I was very disappointed to see this, I must confess. You're here with your lawyer, Mr. Tim George. You've waived preliminary examination in this matter.
That's correct, Your Honor. And I just wanted to confirm, I know Mr. Robert added the traffic counts to the complaint. It started as a ticket. Just want to make sure that there's not a ticket hanging out there to
Let me
worry
look.
about with class.
There might be an amended complaint later. That was the original one, over the counter complaint. Yeah, unlawful use of a license plate, driving without a valid license, and some other stuff. Yeah, one of those tickets is a little wonky. Hopefully we won't get defaulted on that as part of the complaint. But your bond was substantial. A $15,000 PR bond, because you're not, you're local. But you're not to use any alcohol or drugs, you understand?
Yes, sir.
No assaultive behavior,
Yeah,
no firearms or reside where there are any firearms, you understand?
correct.
All right. All right, you waive preliminary examination, same thing. The bond conditions continue to apply. The matter will be scheduled for a status conference in circuit court. Stay in contact with your attorney. As soon as I sign that, this court will lose jurisdiction. It'll be in the circuit court. So don't do any more dumb stuff before we get this taken care of. Hopefully you're working on this with some sort of treatment or something. We'll see. All right, you're free to go.
Thank you, Your Honor.
Mr. Williams, would you come forward?
He's in custody. Your Honor.
All right, and so there's a waiver on that.
That's correct. And that's been turned over to the prosecutor.
All right, we don't need to make a record. Charles Holmes.
Holmes was the funky one that I had talked to you about, Judge. He executed a waiver when I met with him at the jail. Just must have left it in the other vehicle. So I can confirm that he has executed the waiver, and I can get that to the court as soon as I can physically possess.
All right, very good.
And I just have one more at 9:30, but
Yeah, we'll see in a bit.
thank you.
Would you go round up Mr. Truckee? Mr. Fuller is here. Mr. Fuller, looks like you got a black eye or something. What happened?
Honestly, I ran into a cabinet toward corner of my in the eye.
Sorry to hear that.
Last night, so pregnant, but hospital.
What is it?
This is file number 25760FY, People versus Kuran Fuller. That's you, sir?
Yes, sir, it is.
You're here with your lawyer, Mr. Ross Truckee.
Yes, sir, I am, John.
This matter is set for a pre-exam conference this morning. It's got some history to it. It was set for a preliminary examination on the 20th of May, I believe the date was, and you didn't show up. So you should have bench warrant for your arrest. You presented yourself in court on the 28th. And I recalled the bench warrant and scheduled the matter for this morning. I asked for a special hearing regarding Assistant Prosecuting Attorney Gary Gabry. His boss, Deborah Davis, is here. Ms. Davis, is Mr. Gabry going to be present?
Your Honor, he's next door doing the sentencings with Judge Pattison. So it wasn't clear from the email what exactly we were going to be covering.
He was extremely disrespectful to me. He walked into my chambers, called me disgusting, stomped out and disagreed with my recalling the bench warrant in this case, which is a violation of the canons of professional ethics and a great insult to me. He also was wrong on the facts and the law. So he needs to be here and he needs to be prepared to apologize to me. And I'd like to make a special record with him present. If he feels he can come into my chambers and insult me and then stomp out because he disagrees with my ruling, he is sorely mistaken. So I want him present if we can proceed.
We can certainly deal with that issue. I don't know if that necessarily has anything to do with today with Mr. Fuller, as far as what we do with his prelim, but.
Well, let's talk about that. Mr. Fuller, you're charged with being a felon in possession of ammunition.
Yes, sir.
Which is a felony. The allegation is you had 2 shotgun shells. It was at one time set for a preliminary examination. I think witnesses may have even been here. You didn't show up. And then you called the court later that afternoon, as I recall, and the bench warrant issued. Then you presented yourself in court and I scheduled the matter for this morning. I didn't reschedule it for a prelim. I didn't want the prosecutor to have to bring in witnesses again. So, Mr. Truckee, what's our position in this case?
At this time, we're going to leave it on for exam.
All right, in the regular course of business, the exam would be next Tuesday afternoon, June 10th at 1 o'clock. All right, so your obligation is to be here next Tuesday at 1 o'clock.
Yes, sir.
You have a habit of not showing up when you're supposed to. You don't abscond, you just don't appear when you're supposed to. So I let you out. I didn't give you a PR bond. I simply recalled the bench warrant and left your $10,000 cash or surety bond in effect. You held up your end of the deal. You showed up here this morning for this matter. But I want to make a record with Mr. Gabriel before I release you and Mr. Truckee. So I'm not sure what the status is next door.
In the meantime, the people would request that Mr. Fuller be drug tested. He is required to abstain from the use of drugs and alcohol while on bond with his history and his not showing up, and he was 40 minutes late today. We would ask that he be drug tested.
Okay, we'll get to that.
Thank you.
He did call and say he was on his way. His hearing was set for 9. I guess he came in about 6 after 9.
I'm sorry, it's at 8:30 on our docket.
Well, the actual PEC was 8:30. I set this hearing for 9. But all right, he was late, which was about his style. We'll talk about the drug testing in a minute. All right, we need to wait for Mr. Gabriel. Do we have any other cases that are ready to go?
No, I can give you an update.
All right, let's see where we are here. Charles Atkinson.
Charles Atkinson's in custody, and I expect him to take the offer.
All right, so maybe a misdemeanor plea.
Yes.
What's the offer?
2 counts attempted resisting.
Trent Barley.
Miss
That's Ms.
Ives.
Oh, that's right.
She went to go speak with him. At this point, it's still on for exam next week.
All right, let's see. He's in custody, correct?
Correct.
Daniel Barrera.
It's not been here yet this morning.
Robert Lamb.
Robert Lamb is here. I need to speak with Miss Davis or Mr. Robert on that.
All right, we'll come back to that one. William Lowry.
Same situation there.
Courtney Mercer.
She is here. I expect to resolve it. She had a question for me before we move forward, though.
Is there an offer?
There's an offer to use of a controlled substance.
Matthew Tyler.
He's here. That's going to be an exam.
Mr. Tyler, would you come forward, please?
Go ahead. Step aside.
Good morning, sir. Are you Matthew Lloyd Tyler?
Yes, sir.
Mr. Tyler, you're charged with 2 counts of resisting obstructing a police officer. That is alleged to have occurred on May 21st in the city of Sturgis. Cody Midaw and Justin Norrigan, deputies with the Sheriff's Department. Those are felonies punishable by up to 2 years imprisonment and a fine of up to $2,000. Because they are felonies, you're entitled to have a preliminary examination. And that will be next Tuesday, June 10th at 1 o'clock. Let's take a look at your bond conditions.
We're going to place the offer on the record, Your Honor.
Certainly.
So we made an offer of 2 counts attempt RNO. So resolve the case down here in district court. If the preliminary exam is held, that offer would be revoked.
Thank you. So they've got a misdemeanor offer And if you have the prelim, they'll revoke that offer and hold the line at a felony. So I guess you guys can discuss that between now and next Tuesday. You're not to use any drugs or alcohol, you're not to be out past 11 o'clock or before 7 a.m., no assaultive or threatening behavior, and you are under pretrial supervision. Ordered by Judge Pattison. Apparently you've been in compliance with all those conditions of your bond. All right, Mr. Tyler, we'll address this further next Tuesday at 1 o'clock. That'd be June 10th. If you accept the misdemeanor, the plea could be taken at that time. If you don't, there'll be a preliminary examination held, testimony taken to see if they can establish probable cause that you committed this crime. You have any questions?
Your Honor, we would ask about the curfew provision. Mr. Tyler's son is in the critical care unit in the hospital in Kalamazoo. And I don't want us in a position where he's having to choose to violate his bond conditions to be there if things, aren't going well for his son. I don't know
All right,
necessarily.
well,
the
Judge
basis.
Pattison set the condition. I'm not sure what his reasoning was. Ms. Davis, you have, or Mr. Robert, you have any position on that?
Whether he can visit his son in the critical care unit between the hours of 11
11
PM.
and 7, yeah.
I don't even know if there are visiting hours then.
Yeah, I don't.
I guess if there's an exception made to
All
visit
right,
a
I'll
ill
put-
family member.
Per this order, defendant may visit critical care unit after 11 PM.
Thank you, Your Honor.
All right, I'll see you next week. Was that, we'll keep going here. Darren Hodges says Tim Mecleo, Cynthia Miller.
She is here. Expect that to resolve with a misdemeanor offer today.
James Ornelas,
If he's in custody.
Mr. Tyrone Valentine is here. Good morning, Mr. Valentine. And I see Mr. Knopfinger's here. Looked like you have a waiver there.
Is a 7-day waiver, Judge.
Thank you. Hold
All
on.
right, sir. Let's make a record with Mr. Valentine, and then as soon as we get Mr. Gabriel, we'll take care of that
Mr.
matter.
Valentine.
Good morning, Mr. Valentine.
Good morning.
This is People versus Tyrone Wendell Valentine.
Good morning.
Thank you.
Give me one.
Six. File number is 241395, and you're Tyrone Wendell Valentine.
Yes, sir.
This is a charge from last summer, July 25th of 2024, where it's alleged that you committed an armed robbery, I think at the North Main Shell Station. You suffer from ongoing mental health problems. You have dozens of other cases, trespass and disorderly person. You were in the jail for more than 200 days. Went to the forensic center for a competency evaluation, and they found that you were competent, and Judge Pattison made a finding of competency. So at least we can move forward with the case. It's been pending now for almost a year. Mr. Knopfinger, what's the status here?
Yeah, Judge, I'm hoping to look into possibility of a jail diversion. I know that it's been some time now. Mr. Valentine is doing well. He's participating in the ACT team He's involved with the clubhouse down the road. He's gainfully employed. So my hope is to have that worked out before the 17th. However, I'm not really sure where to start, Judge.
All right, well, let's talk about that. You're back at Clubhouse?
Yes, sir.
Are you back employed? Where are you working?
Working back at Applebee's.
They took you back at Applebee's?
Yes, sir.
They did a television story about him on Channel 3 about how well he was doing, working at Applebee's, being involved in the Clubhouse act team, then all the wheels fell off, which they often do when you stop taking your medications. Ms. Davis, do you have any objection to this adjournment, or Mr. Robert?
No.
So we're gonna set a pre-exam for June 17th, is that correct?
Yeah, Judge, was hoping to keep it on your honor's docket.
That's fine. Set for pre-exam at 8:30. And a preliminary examination if needed for June 24th. Are you back at your brother's house?
Yes, sir.
I'm gonna give you actual notice for this. Put it on your refrigerator. I want you, as a condition of your bond, to continue to cooperate with the ACT team. And take all your medications as prescribed. Tuesday, June 17th. I'm glad they took you back at Applebee's. You liked that job. They liked you. You got a lot of cooking experience. So maybe things are getting back on track here. All right. Anyway, this is a serious charge. Do you have any objection, Mr. Valentine, to adjourning this matter out for 2 weeks?
Yeah, I was off my medication and
Well, don't say any more about it. I'm certainly aware of that. But stay on your medication,
Yeah.
all right?
Thank you, Judge.
All right, thank you, Mr. Nosinger. We had a bunch of misdemeanor cases that also got, I think they just got dismissed. He'd been in custody for 200 days on some 90-day misdemeanors. And so I think the only thing that's left is this. Anyway, I'm glad to hear he's doing better.
Hey, Josh, are you done?
All right, could you see how they're doing next door with the sentences? Miss Ives, what do you have for us?
Your Honor, I have Mr. Trent Barley, who had been adjourned to today.
Is Mr. Barley in custody?
He is, Your Honor.
What do you wish to do with that case?
Well, at this point, when I saw him this morning, he was intending on holding his exam. I just talked to Miss Davis a little bit more about the case. I'm gonna go out and see him again, probably today and tomorrow. And I told her that I would update her tomorrow by 5 p.m. about his decision.
So we'll just set it for prelim next Tuesday with the possibility that he may waive.
There's a possibility. I believe it's set at 1 p.m. I do have, I don't know if there's other, is there other exams that we believe are going next week?
Perhaps. There's some set. I don't know whether they're actually gonna go or not.
Sure. Okay.
Is there a plea offer?
There is, Your Honor.
A reduction to CSC 3rd and a charge of CSC 4.
You agree, Ms. Davis?
Yes, Your Honor. And it will be withdrawn and not be available after the preliminary exam commences if he demands on having one. And there will be no further offers. I put it out to the officers. This one.
Very good. Is that the only one you have?
Your Honor, that's the only thing that I do have.
All right, you're good to go. Thank you. We've got about half of them gone. We do probably have some police.
Good morning, Your Honor. Alante on behalf of the people. Your Honor, the people believe any essential conflict between this honorable court and the office of the public defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of all doubt.
Mr. Yeah, you're up.
Your Honor, Mike Gaddy, Assistant Public Defender. Concur with the prosecutor, we don't believe any conflicts exist in any of these matters, but to the extent that any conflict does exist, we certainly waive.
All right. And the court for its part also does not believe this conflict either. The Michigan court rules on the cases decided thereafter. To the extent a conflict does exist, given the waivers, the court will consent to the matter. Court does call the case of the people versus Demarcus Thompson.
Have an arterial requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APA Rich McDuffie, Your Honor.
I know where you're from.
Trenton, Michigan, Your Honor.
Where?
Trenton,
Yeah, you're from Trenton.
Downriver.
Undergrad?
Michigan State, Your Honor.
Where are you in law school?
Wayne State, Your Honor.
Yeah, that's the thing that saved you. Now I remember. All right. Permission to practice is granted.
Have an arterial for the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Thompson, Your Honor.
I have before me a form that indicates that the defendant will be pleading guilty to the charge of false pretenses less than 293-day offense. Upon a successful plea to that charge, count one would be dismissed. There is also an agreement that he must pay $70 in restitution to the mobile on Rossville. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Is that a correct statement, counsel? All right. You want to swear him in? You want me to? Can I have him swear?
Do you solemnly swear affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth? So help you God.
Yes.
Go ahead and lower your hand, state your name, and then spell it out.
Demarcus Jermaine Thompson. DEMARCUS THOMPSON.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of false pretenses less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Correct.
Any questions regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on it.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I'm on probation.
Okay, we were on probation at the time of this offense?
Actually, my probation was just pending at that time. I was just about to get sentenced, so they really know about this.
It's our understanding that they knew about these charges when he was sentenced on the old charge. This is a 22 file, Judge.
Okay, so, but he's not on that same probation, is he?
I'm on the same probation.
All right, then
About to
I understand they may know. I do have to advise you that your entry of a plea in this case could be a violation of that probation. Do you understand that?
Mm-hmm.
Yes.
So yes.
Yes.
And if it is considered a violation of probation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Uh-huh.
Yes.
Yes.
And understanding that, you still wish to plead guilty?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
September 20th, 2021, at the location of 2120 Rossendale Road, Ypsilanti Township, Washington County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
Gave them some money to get some lottery tickets.
You gave them money to get the lottery ticket?
Uh-huh, fake money.
Fake money?
Yeah.
Okay, so you gave them counterfeit?
Uh-huh.
Yes?
Yes.
You knew it was counterfeit?
Yes.
All right. And I think that actually does it. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Defense is satisfied, Judge.
People are satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
July 17th at 10 a.m.
July 17, 2025, 10 a.m. before Judge Washington.
Okay.
Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Cedric Johnson.
And then we have the people, Your Honor.
Thank you.
I think from now on, we need a date at the top.
Edward Lucas on behalf of Cedric Johnson.
And what are we doing on this?
Your Honor, today's the date of set for preliminary examination. At this time, people are unable to proceed as to count 1. It would ask that count 2 be remanded to district court.
We need to dismiss.
I would move to dismiss count 1.
People being unable to proceed on count 1. That charge is dismissed. I'll continue to defendant's not guilty plea as to count 2. Set this matter for pre-trial before Judge Barr on
June 18th at 10 a.m.
And you're
June 18th, 2025, 10 a.m. before Judge Barr.
If I may address bond.
You may.
Your Honor, the serious felony is dismissed in this case. This is actually the second time this matter has been set for a preliminary exam, and complaining witness has failed to show twice. Has another matter set with her tomorrow that's set for final settlement. Based on the trajectory, I'm assuming she's not going to show tomorrow. I'm asking for a reduction in bond. He's got $100 bond in that case. It's actually at 1,010%. I'm asking for something similar to that if it's a 1,010%.
That's your response.
Your Honor, at this time, I'm going to object to modification of bond. This case is set again for exam for the first exam, and then while he failed to appear, he did pick up bond violations with the same victim. So at this time, I'm going to object, and I believe it's something that could be addressed in the pre-trial.
You're right, Your Honor, regarding that, I'm a part of that other matter. Mr. Johnson did turn himself in.
He had 2 bond violations.
The allegations are regarding a location over on MacArthur Boulevard. We would not be objecting to anything regarding a tether where he would not be able to go near MacArthur Boulevard.
What I'm indicating is that when he was released on this case, have bond violations. So he seemingly can't follow direction as to what he's supposed to do and not do. Motion for bond reduction denied, bonds will continue.
Thank you.
That's all that's ready? Really? No, I'll wait. Court does call the case of the people versus William Phillips II.
Alexander, on behalf of the people.
Good to see you on this beautiful day, Your Honor. Robert Ellman with and on behalf of Mr. Phillips, who's approaching. Mr. Phillips, can you please state your name for the record?
William Phillips. Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, people are unable to proceed as to count one. It would ask that count two be remanded.
You're moving to dismiss count one.
Yes, Your Honor.
People being unable to proceed on count one, that matter, that case is, or that charge is dismissed. I'll continue to defend its not guilty plea as to count two. Set this matter for pretrial before Judge Barr on June 18th, 2025, 10 a.m.
Your Honor, may I address bond?
He's out.
Correct. There was
Okay.
there was a
change.
there is a no contact order between the complaining witness and my client, which, as you know, previously she did provide me with a letter requesting contact. I know she shared the same sentiment with the victim's advocate. She's also due to have their child on the 15th of June, Your Honor. So I would be asking for a change in that bond so that he can have contact and also allow him to be present for the birth of his child.
And Your Honor, according to my notes, we haven't had any contact regarding her wanting consensual contact. The last contact we had with her, she confirmed it was her on the phone and then hung up and then didn't mention anything about contact. So we don't have any knowledge as to whether she'd want contact from our
They keep
office.
playing games every other day. Yeah, and they keep, it's like a. What?
Help.
I know it's not. It's like a.
It's okay. Just let it go. Because if she's not here to say anything, he's not going to change his mind. You're just going to dig yourself into hot water.
Anything else, Mr. Elman?
No, Your Honor. Thank you. I just, again, that he would like to be present for the birth of his child.
I understand that, but unless we've heard, and I understand the letter, but I have not heard from her, as I recall it.
Okay.
So your motion for bond modification is denied. Bond will continue with its conditions.
And Your Honor, you said that the case is moving in front of Judge Barr. Did I hear that correctly?
Yes.
Okay, so any emergency bond motion would be in front of him at that time.
I don't know how he handles that, so go for it.
All right, thank you, Your Honor. Good to see you.
Thank you. What's Kilowog doing?
Are we ready on Mr. McCarthy?
Right.
Do we know LOR?
I'm Ms. Elwar, Your Honor. Mr. Peaster is going to speak to Ms. Elwar, the CEO.
Okay. And I mean, do we have any that are ready to go?
We can get Mr. Brown in here. I think the Chalice Mclofflin case is ready to go.
Judge, I may be asking for an adjournment on Wednesday. I'll know as soon as
on. Okay. On Lindsay. Right. For your waivers, one is holding.
Yeah.
Okay. How many witnesses?
I was not provided with.
Oh, is she hearing it today?
She is.
Where is she?
I know she's here.
Anybody know where McDuffie is? Is she ready on her one case? Who's on the other side of that?
Going back and forth between.
Which is,
What?
which defendant is that?
Uh,
I'll be right back.
So maybe I should start yelling at people, then they'll be. Laurer, are you handling one? Why? Don't know? Is it Zenda? She's not letting you.
She let me yesterday.
Yeah, but today's a new day. You want me to yell at her?
No.
Oh, okay.
She's so nice.
She isn't really.
Good, Judge.
I'm great.
Enjoy your Memorial Day weekend.
I did. Had a blast.
Good. Did you call Smith, Judge?
I have not called anything because nobody was here.
But you want to?
Are we ready on Smith?
Your Honor, I believe we are. I may need, my understanding is that Mr. Feaster's present as well.
I have not seen him.
He has 3 of the 4 cases, I believe.
See
Yes.
any violent history.
I'll see if I can find this.
I think he's in fact dealing with his client that with the Arabic interpreter. They're in the front row.
Yeah.
Okay, so I don't know where Mr. Feaster is. We need Mr. Feaster.
40.
Gilders, you came back empty. Well, not, no, you didn't come back empty. Yeah, thank you.
Well, if I was gonna come back empty handed,
Okay, fair enough. I need, where's Feaster? Is that who has the other ones?
Feaster, Feaster actually both Feaster.
It's like herding squirrels. And I don't have a PD in here at all.
Yeah.
Okay.
Judge, if you want Lindsay, I'm gonna be asking for an adjournment.
Why?
Well, Miss Nenda came back.
This Friday, it's my understanding the victim's not here, but the prosecutor's ready to proceed with the police officers. That being said, there's a lot of video I'd like to watch. My client's here. I've discussed that with them.
Why wasn't that done before then?
What? Asking for the adjournment?
The stuff that you're talking about is a review and discovery.
Right.
Why wasn't that done before it was set for PE?
Your Honor, I believe it was set by the public defender's office and then Mr. Kilwall was appointed last Friday.
I was appointed about 4 o'clock Friday. No details were given.
Fine. Thank you, Ms. Sender, for clearing that up. And Ms. Lowe had terrible things to say about you, but I defended you. I just want you to know. Court calls the case, People versus Alante Lindsay.
Good morning, I'm Rob J. Kill on behalf of Mr. Lindsay. What'd you say your name?
Ante Lindsay.
Judge. I was, like I said, I was appointed Friday for what it's worth. There's a lot of discovery. My client wanted to proceed if the victim were here. She's not here, but it's my understanding they would continue with the police officer's testimony, which is fine. I understand that. So I want to review the rest of the discovery. I'm asking, can we get a 3-week adjournment? Is it possible? To the 24th?
2-week adjournment.
I'm in trial with Judge Kuhnke.
My next date is July 22nd.
It's good by me. Is that okay?
Preliminary examination in this matter will be adjourned to July 22nd.
Thanks, Judge. We appreciate you.
2025. That's at 12 p.m. before me.
22nd at 12?
Yes, sir.
All right. Thanks, Judge. Appreciate your consideration.
Can somebody find a PD? There's like 50 billion of them. Mr. Brown? Mr. Brown? Can he handle?
I believe that you can handle LOR as well as.
We've been looking for Mr. Feaster, but I understand on that.
Gets around. He's one of those Flint characters.
I am not gonna.
I'm gonna tell him. Judge Simpson says you get around.
This. Yes.
Okay.
This is, LOR is going to be a competency referral.
Gonna be what now?
Pardon?
Otherwise, gonna be
a competency referral from my understanding. Okay. But we can't find Feaster.
All right. Do you already have the request or I can do it easily?
I don't have any I have nothing. We were just told that.
Okay.
It's right here in the interviews.
But I don't have any forms.
No forms?
I don't have any And on the other
There he is.
I heard Judge Whittle from me.
Yeah, he said that after you got through getting around, that you should come in.
Morning, Judge.
I did agree with Mr. Brown.
My apologies.
Seem to get around.
I
don't know what that means.
Not that way.
No, I don't.
But I am here now, Judge. I apologize for my tardiness.
All right. I was ready on LOR. I don't have any orders. Are you ready on that?
I am, Judge. Yes.
All right. The court does call the case of the People versus Aif LOR.
Good morning, Your Honor. Marie Tanha, assistant prosecuting attorney in that.
Ready, Judge. Torshell Feaster, First Assistant Public Defender on behalf of Mr. Elawar, and the interpreter is also here, Your Honor.
All right. May I have the interpreter sworn?
Can you raise your right hand? Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Arabic and from Arabic into English in the matter now before the court, so help you God?
I do, Your Honor.
All right. Could you state your name, please, madam?
Hermine Dervartanyan, Arabic interpreter.
All right. Thank you.
Thank you, Judge. I have spoken to the prosecutor.
أنا تكلمت مع النائب العام.
And I am requesting an adjournment so that I can complete a competency and criminal responsibility form for Mr. Elway.
وأطلب من المحكمة تأجيل موعد الجلسة لبين ما يتم الإحالة إلى الحكيم مشان الطبيب مشان التقرير.
My understanding is that the prosecution is not objecting to an adjournment for those purposes.
حسب فهمي إنه النائب العام ما عنده مانع إنه نأجل الجلسة.
No objection, Your Honor. However,
لا مانع حضرة القاضي.
to continue the record, we had the victim here for exam last week.
لنتابع الموضوع إنه الضحية كانت موجودة الأسبوع الماضي هنا.
Excuse the witnesses from this week.
حضرة القاضي نعذر الضحية إنه ما يحضر المحكمة اليوم لهذه القضية.
With the purpose of adjournment being competency referral, I'd ask the witness to be excused for the next.
لبينما تطلع نتيجة التقرير.
Why wouldn't I just order the forensic evaluation now?
Please, I can do the paperwork later, Judge, if that's fine.
Okay, because. Go ahead.
ليش؟ لأن لغاية الآن ما صار الأوراق عم يقول القاضي لتحكي حالي.
Because I don't think you're asking for an adjournment to then do the competency. You want me to, okay.
Correct, Your Honor.
لأنه ما أعتقد إنه أنت عم تطلب تأجيل بس لبينما يصير التقرير الطبي.
A forensic evaluation will be ordered. A competency hearing will be set for.
إذا تم أمر لإحالة عند الطبيب النفساني.
September 9th.
September 9.
2025, 9 a.m.
موعد الجلسة القادمة بشهر 9 يوم 9 2025 ساعة 9 صباحا. Yeah, write it for me. He is asking me to write it date.
I am right now, Judge.
هلا سأكتب لك إياها بعد أعطيك.
All right, and there will be no need for witness. Bond will continue.
وما حيكون حاجة إلى حضور الشاهد.
Thank you.
Thank you,
Thank
Judge.
you, Your Honor. Thank you. لحضور الشاهد بخصوص القضية.
يعني شاهد من قبل يعني.
لا، شاهد من الادعاء النائب العام.
Okay.
Court does call the case people versus. They're not here. Court calls case people versus James Sharp.
Andrew Silver's appearing on behalf of the people.
Where'd Tchaikovsky go? Ms. Mackey, how are you today?
I'm good, how are you?
Fantastic. Thank you for asking. What'd you say?
To be here in front of you, Your Honor.
A little bit more sincerity in that. It would have been nice, but thank you. Just a second, sir. We're waiting. Your attorney was just here, which is why we had you brought out, but.
James Fifelski on behalf of Mr. Sharp, who stands to my right.
Your Honor, today's date and time starts with preliminary examination. At this time, the people would move to dismiss this case without prejudice. It may be reauthorized down the line, but we're optimistic that won't need to happen.
No objection, Your Honor.
Case is dismissed. That's without prejudice.
Thank you very much, Your Honor.
Thank you. Thank you, Mr.
I'll try to.
Are you gonna be my attorney?
Where'd he go?
How many witnesses do you anticipate on the Smith matter?
She just stepped out to another case.
Nope, I'm out. I'll come back. You guys get it together.
All right.
So what you got? Go. This is a whole. Hmm. Being held by. This has already started before me. This has already started before me. How many people do they have back there? Thank you. Bye. Bye. Why are you guys still in here?
I'm making my way out, Judge.
All right. We'll find you when we need you.
Just get the change of mind.
All right. They just threw Easter out.
Yeah.
Okay.
I do have a Cody warrant, which no one has given me updates on what's happening.
And thank you. Date and time set for continuation of preliminary examination. Are you ready to proceed?
We're ready to proceed.
All right, let me call your first witness or your next witness.
I call a total of 2 witnesses. My officer in charge, Deputy Bouvet, I'd asked to be present in court, and have Deputy Phillips test.
All right, very good.
People will call Deputy Alex Phillips to the stand.
All right, please come forward, please.
Someone swear for testimony is about to give the truth. But I have to see.
Phillips, Phillips.
You may inquire.
Thank you, Your Honor. And I know that we had kind of started, but I feel like I was only a handful of questions, and I'm basically just going to start from the top.
That's
okay. Because I couldn't tell you where I left.
Okay.
Sir, how are you currently employed?
Currently employed with the Washington County Sheriff's Office.
And what is your responsibilities with the Washington County Sheriff's Office?
Road patrol functions.
And where are you assigned to road patrol?
Ypsilanti Township.
Were you working in that capacity back on April the 15th of this year, 2025?
I was.
Directing your attention to around in the morning hours on that date, had you received any sort of dispatch regarding a potential stolen vehicle?
Yes.
Okay, and can you tell the court about the nature of that dispatch?
We were dispatched to the hotel located at 1275 South Huron Street for a report of a stolen vehicle. Deputy Beauvais and I made contact with the owner who advised that her gray Ford Explorer had been stolen sometime throughout the night.
Okay, and that hotel, do you recall like the brand?
I believe it was the Marriott.
Okay. Based on this information that you received from the person who owned this vehicle and reported it stolen, what did you do next?
We entered the vehicle and Lena and NCIC is stolen. Deputy Beauvais was getting updates on the vehicle's location from the Ford Pass or the Ford application that I was tracking the vehicle.
Okay. And at some point, did you and Deputy Beauvais travel someplace in Ypsilanti Township to attempt to locate the stolen vehicle?
Yes.
Okay, where did you go?
The vehicle was showing in the area of Brook Tree Court and Woodland in the Westville neighborhood.
Okay, this is an area that you're familiar with?
Yes.
Okay. And you proceeded to this area of Brook Tree Court in the West Willow neighborhood in Ypsilanti Township?
Yes.
Okay. What, if anything, did you observe when you arrived in that location?
We entered into the cul-de-sac is on the east side of the road. When we entered in from the west side of the road, we observed a gray Ford Explorer faced on the north side of the road facing westbound, so we could not see the plate. I was in the passenger seat, Deputy Beauvais was driving. We then drove closer to the vehicle to confirm that was the stolen vehicle. Upon getting closer, we observed that the vehicle was occupied. At this point, we believed it was the stolen that was being right in that area, so we initiated our overhead lights to initiate a felony stop.
Okay, thank you. And I'm just going to back you up a little bit. So you are the passenger in your vehicle?
Yes.
Okay, and I don't believe I asked you this. Are you and Deputy Beauvais in a marked or unmarked vehicle? Okay, this is a Ford Explorer?
Yes.
Okay. So you are, I guess, face to face with this suspected stolen vehicle. Is that fair to say?
Yes.
Okay, so you're looking at the front of that Explorer, hence you can't see the license plate.
Yes.
Objection. That's fair. I will rephrase that.
Sustained.
And you proceed in the area as you're attempting to verify the plate. You observe that the vehicle is occupied. Is that correct?
Yes.
Okay. How many people were in that vehicle?
Initially, we could see the driver and a passenger. Shortly after turning our overhead lights and exiting the vehicle, two passengers exited the vehicle.
Okay. So as you're approaching, you can observe at least two people, a driver and a passenger in the vehicle.
Sure.
Okay. Presumably Deputy Beauvais is driving the marked police vehicle that you are in. Is that correct?
Yes.
Okay. So that vehicle is stopped. You activate your overhead lights. Approximately how far is your patrol vehicle from the suspected stolen vehicle?
I would say approximately 20 to 30 feet.
Okay. After you activate your overhead lights, stop your vehicle approximately 20 to 30 feet away from the suspected stolen vehicle, what do you do next?
We conducted essentially a modified felony stop. I unholstered my service weapon and pointed it at the vehicle, began to give the commands, which at this point, the two female passengers had exited the vehicle. So I started giving them commands to face away from me and put their hands up.
Okay. And let me just back you up a little bit. When you took the initial report for the stolen Ford Explorer, was there a color given of this vehicle?
Correct.
Okay. And the vehicle that you had observed was consistent with that color? Was it also consistent with approximate year of the vehicle as well?
Yes.
Okay. What year was the vehicle that was reported stolen?
I do not recall, but I can check mine.
Would that refresh your recollection? That's fine. Do you have your report with you? Okay. If you could just not read directly from it, refresh your memory, and then let me know when it's refreshed. It's refresh.
It is.
Thank you. And what year was the vehicle?
2024 report.
Okay. So you have your weapon drawn, you're giving verbal commands to occupants of that vehicle. Are you physically now walking towards that vehicle?
At this point, I am walking towards and out of the patrol car.
Okay. The Ford Explorer, the suspected stolen Ford Explorer, is it parked on the side of the road?
It is.
Okay. And you said it's on the north side of the road?
Yes.
Okay. So as you exit your vehicle the patrol vehicle that you and Deputy Vevey are occupying stopped, are you up against the curb? Or are you more in the middle of the road?
We're more in the middle of the roadway.
Okay. So when you exit from the passenger side of the vehicle, is the Ford Explorer that you're interested in to your right or to your left? To your left. Okay. So is it fair to say that you kind of then have to walk in front of your patrol vehicle to walk in the direction of the stolen Ford Explorer, suspected stolen? Yes. Okay. And is that what you were doing as you're giving commands to the occupants of the vehicle?
Yes.
Okay. Could you see at this time who the driver of that vehicle was?
Not at that exact time.
Not at that exact. Okay. At some point, are you able to determine visually who the driver of that vehicle is?
Yes.
Okay. How far away were you from that vehicle when you're able to sufficiently see in the vehicle to make that identification?
10 to 15 feet.
Okay. So having the distance that you previously were? Okay. Is the driver of that vehicle in the courtroom here today?
Yes.
Can you identify an article of clothing that they're wearing?
He's wearing orange.
Orange what?
Jumpsuit.
Thank you. Your Honor, may the record reflect an in-court identification of the defendant?
Without objection, record shall so reflect.
Are you giving verbal commands to the driver of the vehicle to do anything at this point?
Yes.
What are you saying?
Standard procedure is yell to roll out the window, turn the car off.
Did the driver, the defendant, appear to follow those commands in any way? Okay. As you are making these verbal commands, is your partner, Deputy Vevey, also saying things to the vehicle? If you recall.
I do not.
Okay, fair. You're making these commands. Is your weapon still drawn?
It is.
How close are you able to get to the vehicle?
Maybe 20 or so feet away.
So you said you had, in order to determine the identification, you were about 10 to 15 feet away.
Correct.
Okay.
But I didn't, when I'm still giving commands, hadn't identified the driver.
Okay, all right. Sorry. And that's my fault then. When you're 10 to 15 feet away and you can see the driver of the vehicle, are you still giving verbal commands at that point?
Yes.
Okay. What happens next?
At first I noticed the parking lights of the vehicle were off, and then I saw these lights, running lights turn on, and then I observed the wheel turn and the vehicle start accelerating towards me.
Okay. While all this is happening, are you saying anything or doing anything?
I believe I was going to stop.
Okay. So the running lights turn on. Did that mean anything to you at that moment?
Means that the vehicle is no longer in park and it's in drive or interior reverse.
Okay. And now the wheels turn towards you and the vehicle starts driving towards you?
Yes.
What happened next?
At that point, when the vehicle is accelerating towards me, I start tending to move out of the way. I didn't have any cover or concealment to my left, so I was able to take about a step or two to the right. At that point, the vehicle's face on with me, approaching me at
what felt like a pretty high rate of speed. At that point, I was able to look through the windshield and identify the driver as Chalice. Tried to step out of the way. I observed him turning the wheel towards me as we were accelerating, and the vehicle made contact with my left knee.
Hit your left knee? Okay. After the vehicle made contact with your left knee, what happened to you?
I spun around and hit the ground.
You had identified in your testimony the driver is Chalice, who we've identified as the defendant in court today. Is this an individual that you had ever previously had any sort of contact with?
Yes.
Okay. Approximately how many times, if you know?
At least 4 or 5. I had interaction with him maybe a week or two prior.
Okay. So the vehicle is driving towards you. You observe the defendant turn the wheel towards you. It made contact with your left knee. You spin and hit the ground. What's the next thing that you remember seeing?
Vehicle sorry away from me.
Okay. So it continued in basically in the direction that you had come in your patrol vehicle.
Yes.
Okay. And what is Deputy Bouvet, if anything, doing at this moment?
At that moment, I'm not sure.
Okay. The vehicle takes off. What do you do next?
Run back to our patrol car while trying to radio. Dispatch.
Okay. You were hit by the vehicle, but you were still able to, you still had enough mobility to get yourself into your patrol vehicle. Is that fair to say?
Yes.
Okay. Did you ultimately suffer any sort of injuries from being struck by the vehicle?
I had some minor hand swelling,
No broken bones or anything? Okay. Do you get back into the passenger side of your patrol vehicle?
I do.
Okay. And what does Deputy Bouvet do?
She gets the driver's side of the vehicle.
Okay. And what happens next?
Attempted to flip around, to chase after the vehicle. That point, Deputy Rob was entering the neighborhood, entering onto Wood Point and observed the vehicle. Attempted to stop the car.
Did you observe that happening, or is this something you're learning over radio?
Learning over radio.
Okay. And Your Honor, I would not be offering it for the truth in matter assertive.
I'll overrule the objection.
Do you and Deputy Bouvet then attempt to engage in a chase with this vehicle?
Yes, but we're pretty far along.
Okay. At some point, do you encounter the vehicle again?
Yes.
And when and where did that happen?
The vehicle crashed out in the area of Ecorse Road in Van Buren Township. On arrival, Detective Rob was taking Chalice into custody and escorting back to the patrol car.
Okay. So about how long in time was that? Did that from the time that you and Deputy Bouvet get in your car and take off to the time that you encounter Deputy Rob with the defendant in custody? How long is that time?
Approximately 10 or 15 minutes.
Okay. And while that 10 or 15 minutes is occurring, is it fair to say you are hearing things on the radio about this ongoing pursuit?
Yes.
Okay. What was the state of this Ford Explorer when you observed it in Van Buren Township?
It was crashed.
Okay.
Pretty substantially.
And you said that you observed the defendant on the scene there?
Yes.
Okay. And what was the condition of the defendant at that time?
Healthy.
Was he in handcuffs? Was he sitting on the grass? Was he laying down?
He was handcuffed, being walked from near the gray Explorer to Deputy Ross.
Okay. Hey, one moment, Your Honor.
Yes.
I have no further questions, Judge. Thank you.
All right. Cross-examination.
Thank you.
Deputy Phillips, do you recall what time it was on April 15th when you encountered the gray Ford vehicle?
9:20.
And that's in the morning?
Yes.
Okay. So you testified that you had been receiving sort of radio reports on the status of that vehicle?
I was being tracked by the Ford mobile application.
So were you tracking it or was someone else tracking and giving you that information?
I believe the victim was giving information to Deputy Belay.
So the person who owned the vehicle was radioing or talking to Deputy Beauvais?
Yes.
How were they talking? By phone?
I believe so.
Okay, all right. And could you overhear the conversation?
No.
No, so you were just getting information from Deputy Beauvais that was communicated to her from the owner?
Yes.
Okay, and then you were being told, okay, this is where they're seeing.
Yes.
Okay, so at some point you make contact or you see the gray Ford Explorer yourself. Is that right?
Yes.
Where is that you see it?
I was in front of, I believe, 2341 Grove Tree Court.
Okay, and you said that's a cul-de-sac, is that correct? Yes. Now you see the vehicle, is it moving or is it parked? Okay, or stationary anyway. And Deputy Beauvais is driving. Deputy Beauvais pulls the vehicle that you're in to within what, 30 feet of the gray Ford Explorer?
Yes, sir.
Okay, could give or take, not holding you to that. Using the distances here, and you're in the passenger seat of your vehicle, I'm going to step back and you can tell me where the front of that gray Ford Explorer was when your vehicle stopped. Ready? Okay.
Was there?
About here? Okay. And you're face to face with that vehicle, is that right?
More or less, yeah.
More or less. Maybe not directly head on, but at least face to face. Now, as you testified, it's a cul-de-sac, is that correct?
Yes.
And as you pull up, when you pull up, are your lights on already?
Not really.
No? Okay. So does your vehicle stop before you turn the lights on?
I don't know if the vehicle was still in motion or we put it in park over.
So let me ask you this. When your vehicle comes to a complete stop, that vehicle is also stationary, is that right?
Yes.
Are people getting out of that vehicle before or after your vehicle comes to a stop?
After the game stop, I believe.
After your vehicle comes to a stop, people begin getting out of the vehicle, the Ford Explorer, correct? Okay. Now, the full time that passes from the time your vehicle stops to the time that Ford Explorer hits you to move on, to go away from where you are, it's about 13 seconds. Is that fair?
Sounds about right.
About 13 seconds. The time from the time you get out of the vehicle and stand in the roadway to the time the vehicle hits you, that's probably about 6 seconds tops, isn't it?
I don't know the exact time.
You had a chance to see the vehicle video of the incident, right? Did you take the time to try to count out the seconds?
I do not.
Okay. Would 6 seconds be fair, or does that sound like an exaggeration?
That sounds fair.
Okay. So from the time you get out to the time that vehicle strikes you to move on, about 6 seconds pass. So when you got out of your vehicle and you're facing, I'm going to be where you are. You're going to be where the Ford Explorer is. You did not go around your vehicle and approach the passenger side of that vehicle, did you? What you did, got out of your vehicle and you moved into the roadway area. Is that right? There's a reason you did that.
To get it out on the side.
Also, you were concerned that the vehicle might try to leave, right? Because as you said, people were getting out of the vehicle, right? All right. And one of the things when you did when you got out is you raised your hand. Is that right?
I believe so.
Okay. And that was for a specific reason, right?
You don't recall.
To stop the vehicle, right? You don't recall that? Okay. So you have a vehicle that you're concerned might flee. You're in the roadway. Now, let's talk about the roadway where you were. This is a cul-de-sac. The space between where your vehicle is and the space where the vehicle, the Ford Explorer, can get past you, how much space is that?
I'm not sure.
Okay. When you got into that space, was there any space where the vehicle could drive around you and past your vehicle without hitting your vehicle?
There may have been.
May have been, or there may not have been, right? Correct?
Yes.
Okay. All right. So the 6 seconds that you get out of your vehicle, you get there, you have your hand up. That vehicle then drives by and it strikes you on its way out, right? Okay. Does Mr. Mclofflin say anything to you on the way out? Okay. Does he even roll his window down? Does he make any threats to kill you? Does he say verbally, I'm going to kill you? You testified that the vehicle accelerates towards you. Is that correct?
Yes.
Again, you are in the roadway between the area where they are and the area to get away from that cul-de-sac. Is that right?
Yes.
So in accelerating towards you, they are also accelerating towards the roadway to get past you. Is that right? Well, let's go back just a little bit. The information you had on the gray Ford Explorer was that it was stolen sometime during the night. Is that right?
Yes.
Okay. Was the owner able to pinpoint a time when that vehicle was stolen?
I believe it was on the surveillance camera. There was a time.
Had you viewed the surveillance camera at the point before you had encountered the vehicle yourself?
Yes.
Okay. When did you review the surveillance camera?
At the start of the shift, when we were dispatched out there, probably 8:30 or so.
8:30 a.m.? Okay. And you said you had contact with the vehicle around 9 something?
Yes.
And I'm not trying to nail you to any time or anything like that. So in the surveillance vehicle, what time was the vehicle taken?
I do not recall.
Would it have been before your shift started?
Yes.
Okay. Do you have any idea if it was that same day or the night before?
I believe it was in the early morning. So that day.
Okay, so it could have been, say, 2, 3 or something around there, right? It's a possibility that the vehicle would have been taken some hours before your shift, right?
Yes, sir.
Okay. All right, thank you. I don't have any further questions for you, Deputy. Appreciate
You're
your
right.
time.
Deputy Phillips, ultimately, did you have to have any sort of medical attention regarding the?
Yes, sir. I went to St. Joe's
Hospital.
Yes, sir.
Thank you. No.
All right, you may step. Thank you, sir.
Deputy Boulay to the stand.
All right. Please come forward, be sworn.
Swear affirming testimony about to give you the truth, the whole truth. So you say your name, sit down, say your name, and spell my name. Go ahead.
What's your first name?
Stopper.
Thank you. And how can you spell that?
Spell that, please. Yes, thank you.
Last name.
Both.
K-A-T-H-E-R-I-N-E. like boy, EAU, like Victor, AI assistant.
Thank you. Ma'am, how are you currently employed? How long have you worked with the sheriff's office?
About 6 months.
About 6 months. Okay. Were you working in that capacity back on April the 15th of this year, 2025? So you would have been only a few months on the job at that point. Okay. Were you assigned with a partner at that time?
Yes.
And who was that? Both of you were in a patrol vehicle together?
Yes.
And you were driving that vehicle? Okay. You were dispatched to the Marriott Hotel regarding a stolen vehicle?
Yes.
Tell me about what, if anything, you did when you arrived at the Marriott Hotel regarding that stolen vehicle.
Upon arrival, we spoke with the owner of the vehicle who advised that her vehicle was taken sometime overnight. She explained it as the Great Explorer.
Okay. And was there some line of communication kept between you and this vehicle owner about the potential location of it based on this app that's associated with this Ford vehicle?
Yes, I advised her, she showed me the Ford Pass app that she had, she could get updated locations. And I advised her if it moved, she got an update to contact dispatch.
Okay. And is that in fact what happened?
Yes.
Okay. Based on the information you received from the vehicle owner, you and Deputy Phillips went to the West Willow neighborhood looking for this vehicle. Is that fair to say?
Yes.
Okay. Describe for the court, and obviously we've already heard the testimony from Deputy Phillips, but describe for the court what you did as you drove your patrol vehicle when you first observed this gray Ford Explorer.
Before making it down the street, I advised that I was in the area, looking down side streets for the vehicle matching the description. I turned down with a rotary report. We observed the vehicle matching the description, 2024 Great Ford Explorer, part of the street, and called out that we were out.
Okay. Did you activate any emergency equipment on your vehicle? Okay. What did he activate?
The overhead lights.
Okay. Did you exit your vehicle?
Yes.
Okay. What did you do when you exited the vehicle?
I did my service on it.
Okay.
Yeah.
What commands were you given?
So when we pulled up, I drew down our and two things had popped up. So I was telling them to let me see their hands, and they were walking towards us.
They were walking towards us. Thank you. The vehicle, are you walking kind of straight towards the vehicle at this point, based on where it is parked and where you park your patrol vehicle?
Yes.
Okay. And you still have your service weapon drawn?
Yes, I was at the low ready.
At the low ready. Okay, so you're not pointing it straight out, but it's down kind of towards the ground. Thank you. You're continuing to walk towards the vehicle and give verbal commands?
As soon as the females had stepped out, I gave verbal commands and stopped walking as they were approaching.
Oh, okay. Is it fair to say at that point you were focused on the females?
Yes.
Okay. Did they walk towards you?
One got out from the passenger side and walked towards Deputy Phillips, and the one from the passenger front seat. I got out and walked.
Okay. After these two females exited the vehicle, could you see if there were any other occupants of this Ford Explorer? How many and where were they seated, if you remember?
One, they were in the driver's seat.
Okay. Were you able to get a visual of the individual who's in the driver's seat of this Ford Explorer? Okay. While this is happening, you're continuing to give commands to the individuals exiting the vehicle. Is that fair to say? Okay. What happens next?
The driver had thrown the lights came on when the females had exited. The driver had turned the lights on, and the vehicle then started to move.
Okay. What, if anything, are you saying while that's happening? Okay. You observed the vehicle. What did you observe the vehicle do after it started to move?
It started moving and started driving towards Deputy Phillips.
Okay. And what did you observe happen next?
Deputy Phillips, was standing there, vehicle drove towards Deputy Phillips, tried to step out of the way, and step out.
Okay. I imagine this happened pretty quickly. Is that fair to say? Okay. During the time that you see the lights go on, the vehicle starts moving and it makes contact to Deputy Phillips. Do you have time to really do anything other than watch this happen? Okay. Do you attempt to use your radio in any way to ask for backup, help, anything like that?
Once we got out of the car.
Okay. So you observe the vehicle hit your partner, Deputy Phillips. Then what did you observe the vehicle do after that?
It continued to drive off.
Okay.
The way that we came.
What did you do next?
I asked my partner if he was okay, we got back in the car and called out that he had just been hit by a car. And we attempted to drive around.
Okay, so then you are driving the vehicle and you're attempting to get involved in the chase of this Ford Explorer. Okay, and we heard from Deputy Phillips, but you eventually encounter the vehicle now involved in some sort of crash in Van Buren Township.
Yes.
And that was about 10, 15 minutes later. Okay. At that point, were you able to make any determinations regarding whether or not the vehicle ultimately found in Van Buren Township was the same vehicle that had been reported stolen from the Marriott that morning?
Yes.
Okay. And that was the same vehicle?
Yes.
Okay.
Over.
And you yourself, Deputy, did have contact with the owner, Miss Wilhelm, of that Ford Explorer? Okay. To your knowledge, had she given anyone else any permission to use that vehicle?
No.
I have no further questions, Judge. Thank you.
Cross-examination. Deputy Beauvais, when you were driving your police vehicle, is that right?
Yes.
Okay. When you pulled up, you were facing the vehicle that had been reported stolen. Is that correct? Okay. And you weren't right up against the curb, were you? Okay. You were more towards the I don't want to say complete middle of the street, but away from the curb with enough space. And this cul-de-sac, is this a 2-lane sort of street?
Yes, it didn't have any fees, but it.
Okay. And when your partner got out, he went to the right of your vehicle. Is that correct? And towards the front. Is that correct?
Not directly towards the front, but walk out.
That's sort of out. So if this is your vehicle, this path would be. For the record, I walked to the right and up towards the front. And kind of go out. Motion. Do you recall if your partner had his hand up to stop the vehicle?
Once it got close enough to him, but not when he got out.
Okay. And do you have a good estimation of the time period from the time he got out of the vehicle, walked into the road, and the vehicle struck him? Was that about 6 seconds? Not sure. Would 6 seconds seem like a crazy amount? Would that seem untrue inherently? All right. So when you spoke with the owner of the vehicle, you said that you told her if it moved in the app to let you know?
Yes, if she continued to open an app and was getting updated locations to let dispatch know.
So did she show you the app initially?
Yes.
Was the vehicle stationary at that time? Okay. But you did say if it moved to let you know.
If she was continually checking the app and there was a different location.
So there was a location established? There was a location established when she showed you the app?
Yes.
Okay. And you don't have any idea whether it was stationary in that location or moving around in that location?
Do you recall initially where that location was?
When she showed me that.
Yes,
I believe it was in Wayne.
in Wayne. Okay, all right. Do you know if there were keys in the vehicle?
She did not have the keys while I was talking to her.
Okay, so I'm asking of your personal knowledge. Do you know if there were keys in the vehicle, of your personal knowledge?
On her person?
No, in the vehicle.
In the vehicle?
Yes. Not sure. Don't know. So you don't know if Mr. Mclofflin had keys or not, do you? Okay. Well, thank you very much, Deputy. I don't have any further questions. Can you redirect?
No redirect, John.
All right,
Thank you. Thank you, Dick.
Mr. Brown and I approach the bench very.
You may. So what I'm going to do is I'm going to okay, record should reflect we had a bench conference in this case. What I'm going to do is there's a scheduling an emergent issue with the other deputy that needs to testify in this case. We'll see if he frees himself up from what activity he's involved in right now at some point. But what I'm going to do is I'm going to pass this matter and we'll call it up later.
And as soon as we relate it to bench, as soon as I have an update regarding that deputy's availability, I'll communicate with the court staff.
All right, very good. All right, thank you.
Yeah, we'll.
Oh, they are. Oh.
Yeah, I got it.
That's these two. And they bring them both in or no?
I'm sorry, thank you.
Yeah, we might as well do one because I don't think they can be.
Not a problem.
Yeah. Okay. Court does call the case of People State of Michigan versus Gregory Callahan. Callahan, I guess. Really.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
And good morning, Your Honor. Reading on P44626, appearing on behalf of Mr. Gregory Callahan, who's present. Standing to my right, sir, would you state your name for the judge, please?
Gregory Callahan. All right. This time set for preliminary examination.
Thank you, Your Honor. This is a continued examination on the Sheriff's Department file number 25-193 on a weapons charge and receiving and concealing a stolen motor vehicle. One of my necessary witnesses is away at a training that we were not aware of, Deputy Roy, and I spoke with Deputy Bechtel this morning, and we are not proceeding on these charges at this time.
All right.
Move for dismissal of the case, Your Honor.
All right. Well, I guess if you're not proceeding, are you nulling these cases? And
I'm not objecting to it. We would just ask that any dismissal be without prejudice.
Yeah, okay. Then what I'll do is I'll dismiss it on the defendant's motion, and that's without prejudice.
Thank you.
Thank you, Your Honor.
Thank you. Ms. Young, can you approach on a separate matter while they get the next individual?
Yes, Your Honor.
Case of the People versus Keith Finley.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Keith Finley.
Your name, sir?
Keith Finley.
Thank you. All right.
Your Honor, today is the time and date set for the continued preliminary exam on Washington County Sheriff's Report number 25-193, carrying a weapon with a lawful intent of receiving, concealing a stolen motor vehicle. Deputy Roy is at training. He's a necessary witness. And I did speak with Deputy Bechtel, who was here this morning, and we're not seeking a second adjournment, and we're not going to proceed on these charges at this time.
Move to dismiss, Judge.
All right. Court will grant the defendant's motion to dismiss this case. This case is dismissed without prejudice. Thank you.
Thank you, Judge. That's a weapons case, not a homicide, okay?
Right.
So I wasn't.
Oh, there's Laura. No, because then I have to clear that if she's not. Okay, where's McDuffie?
There's William, he's not doing anything. Send him. Mike, you're preparing for, he's doing nothing. That's why you get interns. You just relax. See that Laura is all involved in doing what she's doing. She's got to go. What?
But I also need Feaster.
Oh, we need Feaster.
I'll go look for him.
Okay. Somehow or another, I'm gonna send all these people out and I'm not getting everybody back. Who's, he's setting up shop. Okay, but I'm gonna check.
They should be there.
I think they're both coming in, Judge. I think I got
Today?
Can I approach on another matter?
Yes.
Sure.
That the offenses alleged were. Mr. Smith, state your name.
Even Lauren Smith.
And on those three cases, the court's understanding is you're waiving your right to a preliminary examination. Is that correct?
Yes, Your Honor.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you will not have that hearing and on these three cases, and that you'll proceed to circuit court for further resolution.
Yes, sir.
On those three matters, people also waive their right. Preliminary examination having been waived, defendant is bound over on the one count in case ending in 0152. on one count with 2 following in the case ending in 1074 and is bound over to circuit court on the 4 counts as contained in the other matter, the case ending in 5507.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pretrial in these matters will be set for
July 29th at 1:30 PM with Judge Cook.
July 29, 2025, 1:30, Judge Kung.
Thank you very much, Judge.
Bound on those matters. And as to his other matter, are we ready to proceed to prelim?
We are ready, Your Honor.
Oh, yes, the people are ready as well, I'm sorry.
All right. They call you first witness.
Thank you, Your Honor. The people will call Officer Michael Stanky to the stand, please.
Sir, please come forward and be sworn. At 29.
Yes. Someone swear that. Just sit down, go ahead and say.
Officer Michael Stanky, first name CH, last name STAN.
You may inquire.
Thank you, Your Honor, and thank you so much, Officer, for coming today. I'll first want to start with just some background questions. How are you employed? How long have you been there?
Approximately a year.
What kind of cases do you handle?
Wide range, drugs, violence, assaults. That's
Okay. So I want to get a little more specific now and turning your attention to August 17th of 2024. Do you recall responding to an incident on that day? And what area was that?
it's on the east side of Ann Arbor, Airline Drive, Central.
Okay. Now, without getting into what anyone said, can you just generally describe what the reason was for you going to that location?
Sure. I believe the dispatch call was welfare check on a man who was assaulted over a moped, seat on.
Okay. So did you in fact respond to that location yourself? Okay. Were you alone or with a partner?
I was alone.
Okay. What did you find when you got there?
I found a man sitting on a moped, which is perpendicular to the road, stopped. He was slumped over the front. I exited my patrol vehicle and approached him.
Okay. And as you approached, did you get any response from him?
Not initially. I walked to the front of the moped. He was drooling heavily over the handlebars, and then he said something about hi, how are you?
And what happened?
And I believe he gave a verbal response of good, you, something like that.
Okay. And now you said he was slumped over a moped. What did this moped look like to you? What was there anything about it that struck you?
It was red. The kickstands weren't up, which struck me. Both his feet planted on the ground.
Okay.
Over it. Got a basket on the back, I believe.
Okay. And as far as you, why did you mention that the kickstands you said were not up? Were up?
I found it very unusual that him being slumped over. He was able to balance with both his feet planted on the ground.
Okay. I see. So did he take any action with that vehicle at any point in time?
He raised his body up, looked at me, then began to slowly back away, and verbal command, stop moving away from me. He continued to move away, and then he got off the moped and started running.
Okay. Now, I understand you just said that he started running, but I want to back up just a bit from the point where you said he slumped over to starting to respond to you. why did you need him to respond to you? What reason did you have for continuing to interact with him?
Well, I believed he was one of two things, either suffering for a medical emergency or he was some sort of drug or alcohol necessitating an investigation.
Okay, so, what did you do after, as you stated, he began to run away?
I laid the moped on the ground and then I get chased.
Okay, how were you dressed at this time?
Full patrol uniform.
Okay, so when you say you gave chase, is that on foot?
Yes, ma'am.
Okay, and what happened after that?
He ran for approximately 40, 50 yards or so and then tripped. I was able to catch up to him where I tackled him to the ground and then I was able to get the handcuffs.
To be clear, I understand you're chasing him. Are you saying anything or asking him to do anything?
Yes, I believe I yelled at him to stop and I then stop police and he kept running.
Okay. And so at the point where he fell, what happened then?
I believe he fell onto his stomach and I was on his back. I then was able to bring his hands behind his back where I placed him in cuffs.
Okay. And after you placed him in cuffs, what happened then?
I briefly searched his pockets, I believe. I located a knife, some other personal items. I then brought it back to my vehicle.
Okay. And I'm sorry, pardon me. Now, you originally said that you were concerned that he might be under the influence. Is there any other reason that you were concerned about him being under the influence in terms of that moped?
Oh, that he was operating it while under the influence?
Okay, what makes you think he was operating it?
Both his feet planted on the ground, like as I said, so it wasn't, you could say it wasn't parked, kickstand up, where it'd be immobile. So kickstand was down.
Okay. And was there anything, you said that you recovered a knife and you said personal items?
Yes.
Was there anything else that you took from him or found related to the moped itself? Any other items?
Those are the items that I found as a person. After placing them in my vehicle, I went back to the moped. I found a black bag, which I believe had been in the basket on the back of the moped. I looked inside that bag and I found numerous drugs, both illegal and prescription.
Okay. Now, at the point where you went to this bag that was on the moped, that is after that is after this individual was placed in the handcuffs, correct?
Yes.
So was he under arrest at that point?
Yes.
Okay. So what reason did you have for looking into what the bag had in it?
I believe we would be taking him to jail.
Okay.
Incident to arrest.
Okay. You said incident to arrest. What incident to arrest?
I placed him under arrest for resisting instructing or fleeing from me on foot.
Okay.
And then I believe you would be taking him to jail on that charge.
Okay. So you just said incident to arrest. Are you saying that you searched him incident to arrest?
Yes, ma'am.
I just wanted to be clear about that. Okay. Understood. Now back to that moped. What did you find in the bag?
Numerous narcotics. Without referring to my report, I believe there was substances which appeared to be methamphetamine, cocaine, heroin.
Okay.
Pills.
First of all, can you describe why you suspected these substances to be drugs? I understand you said pills. I'll get to that in a second. But what format were these things in? How did you find them? Were they packaged? What exactly were you looking at?
Sure. I believe one of the first things I opened was a container, which may have been some sort of some sort of skin care or hair product. Inside of that were several large shards, which I identified from my experience being methamphetamine. There were several little glass jars unlabeled, which contained white powdery substances, which, based on my experience, is cocaine, and then the pills.
Okay. Now you say pills. What sort of container were the pills in?
I do not recall.
Okay.
Exactly. I have vague recollections of unmarked prescription bottles.
Oh, as in a prescription bottle that did not have a label when you say unmarked?
Correct.
Okay.
Like I said,
Okay. I got you. Okay. So now I understand you suspected that these were certain substances. How did you go about verifying that?
I use an online database called Pill ID. I just run the shape, color, and markings on the pills, and then it will return the results.
Okay. And just generally, I know you've named quite a few different things you suspected, but what kind of amounts did you recover in terms of these substances? In your training and experience, how did those amounts appear to you?
The amounts appear to be far greater than what one would have for personal use.
Okay. And so, in addition to the substances that you suspected to be narcotics at this point, are there any other items that you found of interest?
I believe that he had some drug paraphernalia on it to include needles, aluminum foil, maybe a pipe or two.
Okay. And, okay, now again, so going back, in terms of verifying what those substances actually were, what process did you follow?
I logged them into our police property room. From there, the detective is supposed to submit them for testing. In the state lab.
And did you get results back?
I believe we did.
Okay. Now, I'm sorry, I'm sorry, I'm jumping around a bit. I have to kind of go back and forth. So you submitted the substances that you found in the bag to the lab.
Yes, so.
Okay, but you started out also by saying that you suspected that this individual was potentially operating under the influence. What did you do to follow up on that concern?
I called HVA and paramedics come evaluate him after he continued to appear to be unresponsive or under the influence of some sort of narcotic.
Okay, and what happened after that point?
HVA paramedics were on the scene. They loaded him onto a stretcher. I believe they stated that.
Objection, hearsay.
Understood. Officer, remember that you can testify as to what you directly observed. And if the defendant in this case happens to say something, you can always testify to what he said. But aside from that, I have to have you limit your answers to what you personally observed, not what somebody else said, okay? So again, you can describe what happened. You said HVA loaded him into a stretcher. And what happened after that in terms of following up on the operating concern?
I don't recall any further steps I took on that front.
Okay. So just to be clear, did you receive results back from what you submitted to the lab?
I believe so, but I don't have information.
Okay. Oh, understood. I just wanted to know, but you recall getting results back? Okay. And you mentioned that these amounts you stated were far greater than what you would expect to see for personal use, correct?
Yes.
Okay. So I want to follow up a bit on back to this moped situation. So you've described how it appeared, some unusual things about this individual's appearance with it. Was there any other information you got about the moped itself?
Yes, we ran the started it or stolen.
Okay. And did you have any information on who the individual was that the vehicle would belong to?
Yes, I believe his name was Christopher.
Okay. So is that information, as far as you can see, when you look into lien, is that the registered owner or who's?
I believe he was the registered owner.
Okay, understood. Now, what information did you get in terms of who this individual was who was actually on the moped on this day?
He identified himself as Stephen Smith. They were able to find between a driver's license and we were able to match his photo to his image before him.
Okay, so did you ask him his name directly?
I believe I did sometimes without success, and then other officers attempted to, and then they were able to get his name.
Okay. So, did you take his name and do a search, or how did you connect that with anything else?
I did. I entered the name Stephen Smith into the room and started a driver's license with a photo match.
Okay, so the image that you came up with in your system matched the person that was before you.
Yes.
At that time, I see. And as far as you know, no one by the name of Stephen Smith had any affiliation with that vehicle. Okay. Do you recall, I'm sorry, I apologize if I asked you this already. What substances those lab results showed when they came back?
Only vaguely from looking at the report earlier this morning that I believe certain substances came back testing positive for methamphetamine and cocaine.
Okay. Your Honor, the people are approaching counsel first. Exhibit. Your Honor, unfortunately, the people tried several times to print this exhibit out in hard copy for the court. Unfortunately, the printer refused to do so. Can I display it on the screen?
What exhibit?
People's proposed exhibit number 1.
Which is?
The lab report from Michigan State Police.
I'll just state that although I did file a lab objection, I'll waive
Yes,
that
you did.
objection for purposes of preliminary exam.
Thank you. All right.
Officer, can you tell me what you're looking at here?
It appears to be a lab report from the Michigan State Police.
I can scroll up a bit. Okay, thank you. And is this consistent with the report that you recall receiving in this case?
Yes.
Okay, and just to be very clear, this is from the substances you recovered from the backpack on the moped?
Yes.
Okay. These results are consistent with what you recall?
Yes.
Given that the people would move to admit people's proposed exhibit number 1, which is this laboratory report from Michigan State Police.
Any objection or what here?
No objection for purposes of preliminary exam.
Exhibit 1 is admitted.
Thank you very much. So you described the individual that you saw and the steps that you took to identify him. One of my last questions is that individual in the courtroom today, sir?
Yes.
And can you please just describe him based on what he's wearing and where he's sitting?
Sitting at the defendant's table wearing a white t-shirt.
Thank you. Your Honor, may that record please reflect that the witness has identified the defendant.
That objection record shall so reflect.
Thank you very much. And just to ensure one more detail from very early in the questioning. So you mentioned that this incident took place on, I think, Fairlane and Provincial. What area is that in terms of city and county police?
That's in Ann Arbor, County of Washington.
Okay, thank you very much. I don't have any further questions at this time.
Cross-examination.
Thank you, Your Honor.
Good morning, officer. If you don't hear one of my questions, let me know. I'm going to try to move through this relatively quickly. The first thing I want to ask you before I forget, you came up with information that the moped was stolen, correct? But you did not get any sort of admission or confession from Mr. Smith that he was aware that the moped was stolen. Isn't that correct?
Correct.
Did you gather any other evidence in your investigation to show that Mr. Smith knew the moped was stolen?
No.
Okay. Now, you first testified your reason for being in the area where Mr. Smith was, dispatch called out for a welfare check, right? Did you get any information about what anyone who may have called 911 or dispatch provided in terms of why a wellness check was being requested?
I believe they used the phrasing slumped over. I believe they had tried to give him a drink and he seemed slow, lethargic, and they just wanted him checked out.
Okay. So you had no reason to believe when you first appeared on scene with Mr. Smith on the moped that he was involved in any kind of criminal activity, correct?
I wouldn't necessarily say that.
Okay. Thought maybe he could be under the influence, but you never saw him drive the moped, right? You did not see him operate the moped even once you arrived at the side of the roadway, correct? The moped was not running when you made contact with him?
Correct.
It never turned on while he was on the moped? And other than moving back a few steps when you first made contact with him, verbal contact, when he's walking back on the moped, you never saw the moped move otherwise, correct?
Yes.
Nor did you get any information that somebody had seen him driving the moped around the neighborhood, right? When you are setting out to do a wellness check, what are you looking for?
The physical condition of the person I was called.
Okay. Are you, when you made initial contact with Mr. Smith, did you notice any weapons on him? You noticed a pocket knife after you tackled him in his pocket, but that wasn't an illegal knife, was it?
No.
Okay. When you're speaking to Mr. Smith, your testimony was something to the effect that either you or he said, "Hi, how are you? Fine, good," something like that. What do you remember about him actually saying to you?
I approached him, I asked him what I believe, and he legit said it was very normal. I believe he tried to say, "Good, you," as in, "How are you?"
Okay, but he did say good. Did you have any reason to believe that he was a danger to other people in the area at that time? Did you believe he, at that point in time, was a danger to himself in the immediate sense of the term? That he could do something to harm himself while you're next to him?
No, not besides being on the influence of a drug and being medical attention.
Okay. And sometime shortly after you make contact with him, he gets off the moped and begins to run. Is that correct? Okay. You had a body cam operational at that time, is that correct?
I did.
And have you viewed that to just verify it is what you remember seeing that day? And that's been provided to the prosecutor's office as far as you know? Okay. This is defense proposed exhibit A. I would seek admission of this and just want to ask the officer to view a few moments and then follow up questions. Any objection?
Do you have a specific time?
Just starting at the beginning, the body cam. Approximately maybe 30, 40 seconds.
Okay.
Seek admission of exhibit A.
Objection.
No objection.
Exhibit A is admitted.
Thank you, Your Honor. I plugged in and we'll press go once we're up. Officer, is this you getting out of your vehicle?
Yes.
And this is the area that you made initial contact with Mr. Smith?
It is.
That looks like a neighborhood,
It is.
pretty large yards. Doesn't look like there's any traffic around at the time.
Not mine, too.
Okay.
Yeah, whoa, whoa, no, 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 stop moving. Up on up. Oh, bring it on. Everyone got one run from it. Stop, please. And then you must have started stop.
All right, I'm going to stop it there, officer. is it fair to say that in that short time frame you're talking to Mr. Smith, when he's on the moped, that you did not observe, let me ask it this way. Did you smell any alcohol on his breath? Did you see any drugs or drug paraphernalia on his person? Did you see any drugs or alcohol bottles, what have you, in the basket of the moped?
No.
Did you have any actual evidence other than your suspicion that he might have had a medical or under the influence of something, like you said before? Do you have any other evidence that would lead you to believe he actually had consumed alcohol or drugs?
I believe his behavior was evidence that.
Okay. Have you ever dealt with people that have seizures?
Yeah.
Could it have been that his appearance was that of a person having a seizure of some sort?
No, not a professional. I couldn't testify.
Okay. So until HVA showed up, you would not be able to determine whether he actually could have been involved in a medical emergency. Same thing if he had low blood sugar. Are you familiar with diabetes? People that have low blood sugar, really low, can look like they're under the influence. But you had no information one way or the other whether or not this actually could have been some medical situation for Mr. Smith, right?
Right.
And that's why you, in fact, called HVA later, once you had him under arrest in the back of your patrol car, so they could check him out, correct? And ultimately, he was not arrested and taken back to the police station. He was taken to the, U of M hospital. So you didn't actually book him in order to inventory his property, right?
Not ultimately. No, I'm not booked him to inventory his property.
Not even after he went to the hospital.
Book him, no.
Yes. Okay. So in other words, you didn't have any of his property. If somebody is arrested and booked, then you inventory their property to make sure you have everything checked off, right?
No.
You don't do that when somebody is arrested?
And booked? No, not the and booked. No, just arrested? Yes.
Okay. You, at the time, you told us earlier in your testimony that you arrested Mr. Smith for resisting you as a police officer, correct?
Correct.
But isn't it fair to say that you can't arrest someone for refusing to get medical assistance?
He prevented me from conducting an investigation into whether he was needing medical assistance or under the influence of drugs, right?
Okay, but if you see a gentleman who begins to walk away and then run, doesn't that tell you that he seems to be fine?
No, I would not say it seems fine.
Okay.
He tripped after a short distance.
But he wasn't asking for your help, was he?
What's the point of this question?
To understand why he arrested Mr. Smith the way that he did. Just a handful more questions, Your Honor. So you arrest Mr. Smith, place him in the back of your patrol car, right? He did not resist you putting handcuffs on him, did he?
I don't believe I was called to be only going on. I didn't at the time. But
Okay. And at no time prior to him being taken out by HVA did you conduct field sobriety tests? Or even interact with him to see if he smelled like alcohol or something?
Going down a road that just indicates the officer's conducting an investigation. Because first of all, the moped is illegally placed where it is because it's in the roadway perpendicular to the roadway. That's number one. But are you attempting to ask questions that go to whether or not the officer would have had the right to take that individual into custody or that they were resisting and obstructing?
Yes, Your Honor.
Go for it.
In situations, and again, I've asked you these questions, but you place Mr. Smith in the back of your patrol car. It sounds like you did not ask him any more questions or other than trying to get his name before he went off with HVA, correct? And when you searched his bag, which was near the moped, Did you get his consent?
No.
Did you get a search warrant? Was it within his reaching distance once he's in the patrol car to get something out of it? And did you yourself have any reason to believe, strike that, from the outside of the bag, were you able to see anything that looked like controlled substance or paraphernalia or anything illegal? And unless somebody is a threat to himself or others, isn't it true you cannot take somebody in for a medical involuntary commitment unless they're a threat to themselves or others?
Sure.
And in this particular case, isn't it also true that you did not seek any sort of petition for him to be involuntarily committed, even after he was taken into custody and gone to the
What is the
hospital?
relevance of that?
Again, I think it goes to the legality of the arrest
You don't have,
and the search and seizure.
I get where you're trying to go. He doesn't have to answer that question.
All right, let me ask a few more questions about the, did you field test any of these controlled substances?
No.
The lab report that was People's Exhibit 1 shows 1.88 grams of a combination of methamphetamine, cocaine, xylazine. Do you know where that particular, those substances came from in terms of a container, where they were found?
No, the detective charged that.
Okay. Did you find any logbooks or notebooks showing sales of anything in Mr. Smith's bag or on his person? Did you ever see him selling drugs to anybody? Did you have prior contact with him selling drugs? Did you find any scales inside of the bag?
I believe so. I could reference my report.
Sure, yeah, if you want to reference your report just to be sure.
Yes, he was in possession of a small scale.
What kind of scale was it? Okay. Did you find any money inside the bag? Did you find money on his person? No further questions, Your Honor. Thank you.
Can you redirect?
Very briefly, Ron. Sir, very quickly, you mentioned in the beginning of your testimony that you were concerned that Mr. Smith could be operating under the influence. Is that accurate?
Yes.
Is that a crime as far as you know?
It is.
Okay. And just again, when you were fully uniformed, you asked him, he began running, you testified, and did not follow your commands when you asked him to stop, correct?
Correct.
Okay. You stated that you took him into custody, or handcuffed him rather. And what is the phrase you use about the search for the bag? What was the reason for it?
Incident to arrest.
Okay, can you just explain very quickly what that means?
Sure. Up until the point that HBA tells me that.
Why am I getting an explanation on search incident to arrest? I think I know what that is.
Your Honor, I know that you do. Unfortunately, I was trying to make it extremely brief. Counsel wanted to create a record. I just wanted to very quickly rebut it with about 2 lines.
Go ahead.
As I was saying, until the point that HBA arrives and tells me he should go to the hospital, not to jail, I conducted my investigation as if he was going to jail. I had no reason to believe that he was certainly going to go to the hospital. He was well enough to have run away from me, approximately 50 yards. So I fully believed that he was going to be going to jail that day. So I began to inventory his property.
Understood. Thank you so much, sir. And I think my final question is, when you spoke earlier to the amount of the drugs that you found, you mentioned that it was not for personal use, correct?
I did not believe it was.
Okay. And in your training and experience, what is having an amount of drugs similar to what you observed in this case consistent with, as far as you know?
Distribution of narcotics.
Okay. I don't have any further questions. Thank you.
Real quick, officer. The positioning of that moped in the street parallel to the curb, that's improperly parked if it were parked. Is that correct?
Sort of hard to say as it is, I believe a dirt road, it's not very well marked in that residential area, but I would.
Well, but it's parallel. It's parallel in the road. It's not going with the roadway, correct?
I believe you need to be parked.
Pardon?
I believe you need to be parked parallel to the roadway.
Okay, thank you. Any questions based upon the court's question?
Not for the people.
No,
Question. You may step down. Thank you. Any additional witnesses?
Not for the people.
Any witnesses for the defense?
No, Your Honor.
You have a motion.
Your Honor, the people are going to move for bind over on counts 1 through, let me rephrase it like this. Mr. Smith is currently charged with 5 felony counts. The people are moving for bind over on 4 of those 5. I do recognize that there is some discrepancy with count 4, which is controlled substance possession of analogs. The results shown on people's admitted exhibit number 1 shows that there are markings for that particular substance. However, the detection of it suggested something different that could not be confirmed. I do not contest that those results are basically inconclusive for our purposes, so I am not fighting for count 4 to be bound over. However, I do believe we have met our burden, particularly at a probable cause standard, to bind over on counts number 1, which is controlled substance delivery manufacture of cocaine less than 50 grams. Count 2, delivery manufacture of methamphetamine less than 50 grams. Stolen property, receiving and concealing a motor vehicle, as well as police officer resisting and obstructing. Officer Stanky testified, I believe credibly and reliably so, that he's an officer with AAPD and our police department, that this incident took place within the city of Ann Arbor, County of Washtenaw, that he eventually identified the individual who was on this moped as Mr. Stephen Smith by him, number 1, responding to his own name and stating so, as well as him getting identification, matching him up in lean with that photo and identifying him here in court today. His reasons for stopping were obviously of a concern, given that he was passed out, slumped over the handlebars, as we saw in the video that counsel admitted, and that he clearly had a concern about him being under the influence, as well as potentially operating as well, but certainly being under the influence of some sort of substance at that time. Given that, as soon as he began to investigate that, as a fully uniformed officer, clearly performing his duties, I think that Mr. Smith immediately running away from him by itself meets the standard and the elements for resisting and obstructing, given that he did not follow those commands, knew that that was a police officer, and immediately ran away. In terms of what happened after that point, he did a search incident to arrest, as he mentioned, as he did plan to take him into custody for the resisting and obstructing. That search included a bag on that moped, which held a large amount of substances suspected to be controlled substances, which were then proven to be so in terms of being cocaine and methamphetamine, as shown by people's admitted exhibit 1 for the Michigan State Police laboratory results. Finally, he ran a report on that moped that Mr. Smith was found on, saw that it showed up in lien as a vehicle that had indeed been reported stolen. And it was not obviously affiliated with Mr. Smith in any way. Given that, the people believe we have met our burden and we move for bind over on those 4 counts, counts 1, 2, 3, and 5, excluding count 4.
Response.
Your Honor, as far as count 3, receiving, concealing stolen property, been no testimony or evidence presented that Mr. Smith knew or had reason to believe or know that the vehicle, the moped.
But isn't that a factual question?
I think there has to be some probable cause. I don't think so. I think in a case like this, it may come up as stolen, but there has to be some evidence that Mr. Smith was aware of it at the very least. And there's nothing here presented in the testimony.
Okay, go ahead.
I think more importantly, and I think that cuts to the heart of 2 different issues, is that under the resisting and obstructing police officer, one key element is that the officer gave the defendant a lawful command or was making a lawful arrest or otherwise performing a lawful act. I don't see how the law or the Constitution allows a police officer to turn what is a wellness
You
check.
need to give me some case law, because I'm not gonna argue law by Fifowski. I sat there and watched your exhibit. Your exhibit clearly indicates the officers in the performance of his duty, tells him, hold on, hold on, hold on. It's grabbing the front of the bike. The officer is in the middle of the investigation and your client gets off the bike, takes off. So you show me a case that where that is not resisting and obstructing, I'd like to see it.
Your Honor, there's a case, the City of Troy versus Olinger, Michigan Supreme Court, 438 Mich 477. This is talking about using the community caretaker exception to enter a house. But this is essentially what a welfare check is. Community caretaker of a police officer. It's not going to investigate a crime.
It may have determined, Mr. Fifowski, you're jumping to conclusions. When the officer arrives there, he's not sure what he has. He's investigating a potential crime or some wellness. He doesn't know, as many officers don't. One of the things is during the course of that initial part of that investigation, he tells your client to stay put. He doesn't. He takes off.
But
he gave him a lawful command and he didn't follow it.
But I think the question comes up as to what authority does a police officer have to detain someone on what initially starts as a medical check, a wellness check. If the observation of the individual is that he gets up and is able to move around,
he doesn't know that though.
Unless he's a threat to somebody else.
You can argue that at trial. Go ahead with your argument.
Well,
because I'm going to tell you, you're just wrong.
For purposes of the record, I'm making that argument. I don't believe it's a lawful arrest. And I believe that the ultimate search of the bag that yielded the controlled substance was equally unlawful, since Mr. Smith was already in the back of the patrol car, could not reach the bag, and therefore it's not search incident to arrest under Gant, Arizona versus Gant. And lastly, the lab report tells us there's 1.88 grams of a combination of methamphetamine, cocaine, and xylazine. We have charges of possession with intent to deliver less than 50 on counts 1 and 2. And while the officer testified there were other drugs, we don't have any indications of amounts. So I would ask that this, and without something more, again, in terms of actual measurements of these other substances that the officer found, he says there was a scale. He says it looks like more than somebody would have for personal use. But without some more evidence, that is more speculation than I think it is for probable cause for bind over on possession with intent to deliver. So I've made my request that the evidence should be suppressed and all the charges should actually be dismissed.
Anything else on that?
Extremely quickly, Your Honor. Not that this is going to be outcome determinative, but the case that counsel cited, City of Troy versus Olinger, concerned whether or not an officer may enter a home without a warrant when he believes that the person inside that home may be injured in terms of that community caretaking function. I don't think that case has anything remotely relevant to the facts presented here.
It's not applicable. Factually, it's not applicable. Court, having heard the testimony in the case, the court believes that the people have indeed sustained their burden of finding the defendant over. It may be a factual question as to the amount, but certainly you can argue that in circuit court. And so as to the drugs at issue in count 1 and 2, the court would find that the people have sustained their burden. And it's also to count 3, there is, he sufficiently, if the issue is that he didn't have knowledge that the bike was stolen, then certainly counsel's free to argue that in circuit court, but that creates a factual issue. He's there present on a stolen motor vehicle. And then when questioned by the officer and held by the officer, takes off, but later on it's determined that that vehicle is stolen. I think that's sufficient enough evidence regarding the count 3, the receipt and concealment of stolen property, motor vehicle. As to count 5, the resisting and obstructing. I don't even understand, quite frankly, defense's argument, because the cold-hearted reality is the officer gets there, and what negates defendant's argument more than anything is their own exhibit, defendant A, or exhibit A, which clearly lays out what the officer is doing. The officer is investigating a circumstance, and as I indicated, like with many officers, they don't know exactly what they're running into or what they have in front of them, but he's noticing certain things. He has gave him a lawful command to remain where he was and not back that vehicle up, and then he proceeded to take off. Even when he took off and the officer then says, "Stop, police," that in and of itself can constitute the offense of a resisting and obstructing after he began to run, because that was indeed, in this court's opinion, also an additional lawful command. So for those reasons, and because anything else in dispute creates a factual dispute which needs to be resolved by the finder of fact, court would find that people have sustained their burden and would bind the defendant over to stand trial on counts 1, 2, 4, and 5.
Acknowledge receipt of the information and waive formal reading and stand mute as to counts 1, 2, 3, and 5.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set for
July 29th at 1:30 p.m. with Judge Conley.
July 29, 2025, 1:30 before Judge Conley.
Thank you, Your Honor.
As to his bond, I have a violation report.
Yes, Your Honor.
Well, how come he hasn't reported to community corrections after his release from custody?
He had been in custody since about January of this year. And in speaking to Mr. Smith, he was only released from the Jackson County Jail about 2 weeks ago. He had bonded out on all these cases. When he was arraigned, I believe he was told, because he was also on probation in Monroe County, that
if he goes over there and tests right now, is he going to test clean?
He should be clean, Your Honor.
Go over and test. He needs to come back. You'll need to remain here, and then I'll set his bond. How many more we got?
Got 3 more for sure that we're holding. Haven't heard from Mr. Brown yet. Don't know.
Mr. Brown. But
Mr. Brown was the recall on Mr. King. I don't know what we're waiting on.
All right. I'll stay in brief recess. I'll come back, line them up, and that's all right.
From those 3 days, and throughout the whole, me having my whole device and whatnot, we haven't had those type of numbers. I never had to have these encounters. Like, this is like, I honestly could swear to you that I have not touched a lick of alcohol at all, at any type of point, at any given point. I even looked it up. I did research. They even said that if I'm in a hot room, if I'm in a hot place with a bunch of people rubbing against, like, I'm a security guard. My job is literally to escort people out and whatnot. Like, that's the only way I couldn't possibly ingest alcohol directly in any way, form, fashion at all. Like, I'm not at all. Like, you can see it's 3 days straight and it's all around the same time. And that's around the time when we started. Like, we open, I go to work at probably like 8:30 and we start opening up around 10. So people are flooding in around those times because we had a dream con event at, at the George Rogers Brown Center. So the after party was at my music venue at Warehouse Live in Midtown. And I promise you, I have videos, I can show you how many people was there, and I can show you all that, I can guarantee it. I wouldn't dare disrespect anything that I have given me by just, you know.
So, my problem is, look, this is what I'm gonna say, Ms. Foster, I understand that you have a and you are, that's your story, and you're gonna stick to it, and you get to stick to whatever you want, okay? But the reality is, I'm not gonna put you in jail, so if you wanna sit here, because you think if you convince me of that, I'll put you in jail, I won't even put you in jail.
No,
So the second is, I've been doing this a very long time, okay? Yes, I'm a little cynical, and a lot of people stand before me and declare like you're just doing, and in the end, this is what it is. And I'm gonna be totally honest with you, whatever has happened, okay? Now, these devices, and we've had a lot of research, and we've had hearings, and if you wanna stick to that story, we can have a hearing on it, okay? And I can bring somebody around. Now, I have had situations where if people are, I have a situation that someone is a bartender, okay, and is constantly handling, and they're handling them, and they're doing those kinds of things. That could expose their system to alcohol, and that could potentially. But here you are, what you're kind of expecting or hoping the court would believe is that you have a device, which is on your ankle, that you have on long pants, and just the mere fact that you were in a crowded space is gonna make it read alcohol. I mean, hey, if you wanna stick to the story and you wanna have your attorney have, you can have a full hearing on it, and I'm sure are you hired or?
I'm hired.
And I'm sure he's gonna charge you for that. We can do all of that, okay? Or we can just, you can chalk it up and say, I don't know what happened. Maybe each night I accidentally drank a Coke and it had bourbon in it. I don't know, okay? Or it had some kind of way in it. Because at the same time, I am a person that is very familiar with the kind of situation that you are talking about. Like, in other words, I host and there's a show and there's other stuff. But I can tell you the chances of this gram device just registering alcohol out of the thin air from your skin is very slim. Okay, so that's almost a period. Okay. I don't know what happened. Do you have notes in there for the alert thing? Because Judge Roth that ordered the scram, he put in the notes, so I don't know what happened.
Yeah, so he had an incident where he did consume alcohol in that incident, so that's why he got it.
Okay, because I'm trying to see, that's so funny, because I don't know what happened.
I was here, so
I know, but I was looking for,
some notes, I guess.
yeah, because normally,
And if you want to take it up, I'm okay.
you know that may not be. But the reason I'm saying is that unfortunately, my regular, pre-trial person is not here.
Yes.
I don't even show that violation in the file here.
Yes.
I'll let you finish, Mr. Bell.
I'm done right now, just didn't catch his name.
Craig Foster. Apparently, he had a previous violation. And Judge Ross was here while I was, his signature's terrible, but I couldn't figure out who it was.
You haven't seen mine.
And Judge Ross ordered him to get the scram.
That looks all good.
Okay, when was that? I don't know why I don't have that BBR in the file. This is his second. So let me tell you what this steps approach is this policy. I'm sorry to hurt your feelings, but I don't believe you, okay? But that's okay. Because you're gonna figure some stuff out. Because what happens is people that have unhealthy relationships with substances are not the most honest people, because they're not honest about their relationship with the substance. So, and I hate to just inform you, but that's the standard. And lots of research and stuff around it, because a lot of people just don't deal with their issues, okay?
Yes, ma'am.
I don't know, but we're gonna point you in the right direction and give you an opportunity to potentially explore what I'm seeing here, what I'm seeing by these patterns. Because my perception is you have an unhealthy relationship with alcohol. Maybe you do, maybe you don't. I'm not an expert, okay? But I do think you need to explore that. I'm gonna make you go to 2 AA meetings a week until this case is resolved. So you'll go, they'll be in person, okay? And maybe you could do some soul searching at that and determine who you're attempting to fool. If it's you or me or society, and maybe I'm wrong. I don't know, okay? But unfortunately, I mean, you're in a position where, you know, the judge can be wrong, but you can't.
He went into the breakout room.
Okay? So, that's what I'm gonna do. I'm gonna amend the conditions. We're gonna keep this gram on. Okay? And he'll go to 2 AA meetings a week. Now, let me be clear. The very next step, because right now, I need you to understand, Mr. Foster, you're on my bond. You got a general order bond. My name is on it. I am vouching for you. And right now, is it? So I need you to understand, the next violation, if there is one, is that I will not stay on the bond. So you better get your money ready to make a bond. Okay?
Yes, ma'am.
Okay. Now listen, I am sympathetic to the fact that if you have an unhealthy relationship with alcohol, that it's not easy. Okay? But my advice to you, and I know this is your first time really talking to me, is that everyone will tell you, Judge Jackson is very fair and very honest when people acknowledge it and when they deal with their issues. Because stopping alcohol, if you have an unhealthy relationship, is not a light switch. It's not something that you can just do. And I know that there's no perfect time that anybody's going to be perfect. Okay?
Yes, ma'am.
That's where I am. Thank you, counsel. Just having signs in the bottom.
Thank you, all.
Thank you.
Thank you so much.
Thank you.
Now, for briefly, Judge?
Come on, yeah, because I my jury out in the hall.
I didn't see him out there.
Okay, okay.
I have Miss Silva.
They run late today. Yeah.
Busy day today.
Ms. Silva?
Angela Silva.
Yes, yeah, she was late, so you got a point late.
Well, no, this is another case.
Oh, okay, I'm sorry.
We're here. She has another bond violation.
I don't have all my bond violations today, I'm sorry.
Party and interest is Aaron Purcell. They didn't show up again, Jennifer?
No, Your Honor, I've not had him check in with me and we've not received any call. Last time we called him to get him here and he said that they hadn't received notice.
They had?
I did mail it out after our hearing.
Sent out another one, case dismissed, plaintiff failed to appear. Again, they might file a motion to set it aside, but that's it. I mean.
Thank you, Your Honor. Have a good day.
You too, thank you. Do I have Michael Walters versus Nicholas Martin here?
Good morning, Your Honor. Michael Walters.
2500060.
I don't see Mr. Burton.
Do you know your name, sir?
Michael Walters.
Well, I mean. What in the world is this? Where's your,
This is a transfer from the 27th in Wyandotte.
Well, I know that, but
Okay, sorry. Assuming I knew your
you're
question.
suing for $7,000.
Correct.
And we have proof, Jennifer, that there was service on Mr. Martin?
Your Honor, everything that the Wyandotte court sent, I printed, so if it should be in there.
Well, how do you come up with $7,000?
The purchase price was $6,800, and then I was also able to claim, at least I think I claimed the court cost for the filing, that was $100, and I've been paying insurance on the vehicle for the last 7 months, storage, obviously. So it's more than that, but I guess for small claims, I can only go to 7,000, is my understanding.
What, the car did not run?
I don't know if you saw the paperwork that I submitted.
I have not. I didn't. I'm
Okay.
just picking it up for the first time.
Okay, gotcha. So, I can hand you this if you want to look through. I got a
Let me ask you to raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings be the whole truth, so help you God.
I did.
Go ahead. Now tell me just real quick what you have.
Okay, so my son is a sophomore at Michigan Tech up in the Upper Peninsula, and he's been looking for a vehicle to take up with him, right? So all summer we spent looking for vehicles. Unfortunately, we didn't find one, so back in October, he found this one on Facebook Marketplace with Mr. Merton. It was a 2004 Chevy Colorado. It was advertised in clean condition with rust. I looked at the vehicle, gave it a quick inspection and drive. And he said there was a transmission leak. And Mr. Merton, he denied that, I guess. He said he never saw any drips on the driveway, in the garage, whatever. He has a small business down in Flat Rock where he has hoisted multiple things. Long story short, my son's like, Dad, it's a good deal. He goes, I think we should buy it.
Okay.
An hour after I looked at the vehicle, Mr. Martin contacts my son again through Facebook Marketplace, says, hey, your dad just left. I had another guy look at it. He offered me, I think he wanted $7,500. He goes, the guy offered me $6,800. He goes, your dad's here first. If you'd like to purchase the vehicle for $6,800, I'll give you the same price. So come Monday, I went over and looked at the truck again and said, okay, my son really wants the truck. We'll agree at the $6,800. One thing I did notice when I looked at the vehicle on Friday, November 1st, the back end was sagging a lot. But he's in construction, he does excavating. So the whole back of the truck was full of concrete saws and other tools and things of that nature. I'm guessing maybe 1,000 pounds worth of stuff, right? So on Monday, I go look at the truck again, the truck's still sagging. And something just doesn't seem right. Purchased the truck. The very next day, I take it to our mechanic, who also lives in the Flat Rock area, has a business, put it up on a hoist, and the entire frame is running out.
Okay, so what month was that?
Back in November.
And you paid insurance for how long?
I'm still paying it out, so from November 1st until.
Is the car been drivable?
Nope. Car has 18 miles on it right now. I haven't driven it since the second day.
Why are you still paying insurance instead of just getting storage coverage?
It is, it's storage. That's what I'm, yeah. So I don't have full coverage or,
I'm gonna go ahead and give you, you know what, he didn't show up, I've heard enough. I'm gonna give you the $7,000. I'm also going to give you your filing and service fees. How much did you pay in storage coverage?
I'd have to go back and look, let's say $50 a month.
Okay, you know what?
6 months, $300.
I'm just gonna give you the 7,000. He has it looks like a $70 filing fee.
Right, $30 to serve him with the papers.
Is that what it was, 30?
$29.85 or something.
Okay. So your total is $7,099.85. Defendant is in default. Defendant failed to appear. This was scheduled for 9:45. He was given 15 minutes. It's now June 3rd. I just filled out the small claims judgment in his packet, Jennifer.
Thank you.
Pull that
Yep.
out, copy of Julie. Thank you. You're all set, sir.
All right, thank you very much. I do have one more question for you, Your Honor.
Yeah.
How do I collect?
Yeah, you need to talk to a lawyer about that. You really do. You can garnish wages. You can schedule a creditor's exam. I'd speak to a lawyer about it and get your full.
Does he get notified?
Yeah, but you should call him in 3 weeks and say, hey, where's my money?
Okay. But he will get notified of this order?
Yes, we're gonna send it out to him.
Awesome, thank you.
Have a good day.
Thank
Good
you.
luck.
Thank you.
David Allen Story, 23F2408-208.
They're all in custody, I gotta get them out. We got 2 of them. He said she wants to see her out there.
So you're getting
I'll get
Loringer?
Story out first.
Jeez.
You got 2 of them back there.
Do we have Flat Rock out there? We have Flat Rock?
I don't even know, Your Honor. I was out of the courtroom. I got. You need a detective from Black Rock?
I need Story. I need.
You got Mr. Westmoreland's out there.
We're
Which
ready on
one?
Lewis. I believe she's in a breakout room, but she's not in custody.
Which one do you have?
Lewis, Story, Loringer, Burton.
You got all of them?
Yep.
You need a detective from Black Rock, Your Honor?
Yeah, I do. Okay. Yeah, we need Flat Rock out there on all these. Are all these guys in Flat Rock?
No one's in custody at Flat Rock. Derek Loringer and Shamia Lewis both zoomed in on their warrants, and the other guy is in person. They dropped him off. He's in the jail cell.
You got 2 guys here. All right, thanks.
Wait a minute, I'm lost. Who is in custody in the building here?
Story
Loringer?
and Burton.
Where's Loringer at?
He's on Zoom.
On Zoom.
He's got to come in. This is a felony.
He's in a treatment center. He zoomed in this morning.
All right, get them all out, and I don't know what else to tell you. Get Flat Rock on.
They're on their way.
Mr. Westmoreland said he's on Zoom.
I'm lost. I don't know what we're doing here. Where's Shamia Lewis at?
She should be in a breakout room.
Shamia Nicole Lewis, 24R513-561, 24R513-559, A and B.
Corey, did you talk to her?
I did. She's probably stuck in a breakout room.
No, I don't see her.
Oh. Yeah, no, I just spoke with her a couple minutes ago.
Why didn't she show up here? I don't get these people. I'm not canceling these warrants when these guys don't show up in a year and then they decide they're gonna zoom in. Like, okay, really?
I didn't talk to her, Judge. I just know that Loringer's in a treatment center.
Yeah.
He zoomed.
Is there a phone number for Miss Lewis in the file? I can give her a call and tell her to jump on Zoom again.
This is a mess. I don't know what happened here, but I don't see any phone number. And I'm sure not. I don't even know. You don't see her out there. What about Loringer?
Loringer's on Zoom.
Are you representing Mr. Loringer?
That's correct, Judge, and I already spoke with him.
David, okay, let's bring him in. Derek Francis Loringer, 24F709-863FY.
Mr. Moore?
Wait, he's not ready yet. Have a seat there.
Good morning.
Morning.
The People of the State of Michigan versus Cody Moore.
People? And Alex Warren Green on behalf of Mr. Moore. Just state your name, Mr. Moore.
Cody Moore.
Your Honor, today's date and time for preliminary examination. I had an opportunity to speak with Ms. McDuffie about Mr. Moore's case. We are respectfully requesting an adjournment to, I'll leave it in the court's discretion.
Why?
Your Honor, if I may, we have discussed the resolution in this case. I just need a couple of weeks to get the information that we need, and I believe I'll be able to send the knowledge to the court once I receive that in the next 3 weeks or so. For Mr. Wilbur.
That's my understanding, Your Honor. We did attempt to contact Mr. Moore's parole agent. We need to follow up with her. Want to track Mr. Moore's progress over the next few weeks with respect to his drug testing.
Preliminary examination will be adjourned to June 17th, 2025 at 12 p.m.
You don't have to come back.
Continue.
That's setting.
She said that's what she meant.
We have. They get any information yet on the availability?
No, I don't have any information on that.
Okay. That's called the case, People versus Montel Gap. 2 cases. Mr. Brown, you didn't have any information yet on that? Okay. It's here? Okay. Oh, okay. So, well, let me try to do this one real quick and then I'll get that other one out of the way. But, well, the officer's here. Officer Rob's here.
No, he's not.
Oh, okay.
They're still on their calling. Still.
Okay. All right.
So if we want to recall that at this point,
I don't know.
How much you care about Mr. Brown's schedule?
I'm gonna do this one. Brown, he goes someplace and take a nap. He'll be back.
A lot of important meetings on this.
Is that right? All right, we're ready on Gatlin. Right.
Andrew Childers appearing on behalf of the people, Your Honor.
Assistant Public Defender Ben Dennis on behalf of Mr. Gatlin, who stands to my right. You state your name for the record, sir.
My name is Montel Gatlin.
Thank you. All right. 8 times that. Oh, yes, sir.
Hey, John, before we proceed, I would like to just take accountability for what I've done. I would like to plead guilty to.
Hold up.
No.
Mr. Gatlin. No. Hold on a second. Okay, hold on. There's a process to it, okay? And so I hear what you're saying, not discounting it, but this would not be the place to do it, to do that right now. The question would be today, given what you kind of just said, is to whether or not you want to have this preliminary examination.
I would like to hold it and I would like the court to hear me out. That's it.
So you want to hold your preliminary examination?
Yes, I would like to hold.
Okay. Did you want to speak further with your counsel, given what you just said? And
I would not like to speak further with my counsel. I feel like my counsel
is what?
Okay.
All right. Okay, but I just want to make sure, and I'm doing this because I want to make sure things are fair for you, that you understand this isn't the point at which you would testify typically. You understand that?
Yes. Yes.
Okay, that's what I'm trying to. So here's the thing, Mr. Cameron. You said something to me or said something out loud, stopped you, right?
Yes.
Then when I asked whether or not you wanted to have your preliminary examination, you then stated that you want to be heard.
Yes.
Okay. This proceeding, the preliminary examination, not saying it hasn't happened before, but this particular proceeding is not one where you would typically be testifying or saying things to the court.
I would love to if you would give me a chance.
Okay, well, let me do this, okay? Because again, I'm not disputing anything that you may want to do. I just have to make sure that you're not doing something that may jeopardize your rights. Okay. So what, just bear with me. I got to do my job, right? Okay. All right. So I'm hearing you. I think what I'm going to do is I'm going to pass the matter. I'm going to let you just briefly talk with your attorney and maybe the chief deputy of the public defender's office so that process-wise you understand it and understand what typically will happen at this proceeding and what won't happen, or what, strike that, what typically happens at this proceeding and also what typically does not happen. Okay. And I think you may be asking to do something that typically does not happen. And I just want you to be clear on that. Okay.
I'm just trying to plead to all.
Stop. Hold on. I hear you. If that's what you want to do, there's a way maybe to go about doing that. Okay.
I don't think they want to help me. I don't.
Well, hold on. Stan, I hear you. Okay. I'm trying to say it in a way. Here's what I'm going to do. I'm going to pass the matter. We'll find Mr. Brown. I'm going to have you talk to Mr. Brown. All right. With the PD's office, just to make sure you're clear on everything, because I have to make sure that your rights are protected. Okay. So we're going to do it that way. We're going to do it my way, that way. All right. That may mean you might come back up and I might be in the same boat, but I just have to make sure. Okay. Fair enough. Okay. So let's take him back.
Your Honor, real quick. Okay. Yeah, matter of fact.
Take him back. Counsel approach, please.
There he is.
Derek Francis Loringer, 24F709-863FY. Mr. Loringer, your name.
How you doing, Judge? Derek Longer.
Attorney Corey Westmoreland praying on behalf of Mr. Loringer, Your Honor.
Do I have Flat Rock coming in? For purposes of arraignment, how does he wish to proceed?
At this time, Judge, we are prepared to waive a formal reading. My client stands mute.
You have the right to remain silent, Mr. Loringer. You don't have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to a lawyer not only today, but at all subsequent court proceedings. And if you ever choose to submit to questioning with law enforcement officials, you do have the right to be represented by your lawyer at that questioning. Do you understand that?
You know, I didn't tell him to stand mute, Your Honor. I'm entering a not guilty plea.
Did you hear what I just said, sir?
Yes.
Why are you talking about entering a not guilty plea? I didn't ask you anything about not guilty. Do you understand everything I've just said?
Yeah.
You have the right to a probable cause conference within 14 days. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary exam, the people have to show is to each one of these crimes that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, then the case would be dismissed and you'd be discharged. But you have here 2 felonies, assault with intent to do great bodily harm less than murder or by strangulation. And you have felonious assault. Those are 10 and 4-year felonies respectively. And you also have a 4th offense notice. If you're convicted of anything that carries with
They
it
know I'm waiting on
5
results.
years or more, you could get life. If you're convicted of anything that carries with it less than 5 years, you could get 15.
So
You
he's
understand
back,
that, sir?
then I'm waiting on Rob, then I'm waiting on
I
Gatlin.
didn't hear you.
Then I basically got a clear area. Where
Wait, you gotta get
Okay.
closer to the device. Do
So
you
I have to
do you understand
give
everything?
that time debate. Court's gonna stand in brief recess.
I didn't hear what you said. Did you hear what I told you and understand what I told
You may be seated.
you?
Your Honor, yes, I hear you. Can you hear me?
A little bit, but I didn't hear what you said. Do you understand everything I told you?
Yes, I do, Your Honor. I'm sorry. We must have a,
Just stay close to that device, okay?
okay.
All right. Now, so we're giving you those dates. June 17th at 9:30 will be the probable cause conference. June 24th at 11 a.m. will be the preliminary exam.
Okay.
I'm going to need somebody from Flat Rock. Lieutenant Rembez, your appearance?
Let me write that down, Judge. You said June 17th.
Lieutenant, your name?
Morning, Your Honor. Detective Lieutenant Chris Rembez, Flat Rock Police Department.
Do you know anything about this case?
I do not, Your Honor. Is it Mr. Loranger?
Yeah. Can you take a peek at the file and tell me if you think, I don't remember doing this, whoever did this. It looks like Judge Kirsten actually did this, signing on record, back in May of 24.
I'm trying to check now, Your Honor. I apologize.
That's okay. Take your time. And I didn't include the assault and battery charge that you had, Mr. Loranger, which is just that's a 93-day misdemeanor, of course.
Judge, is the file on this one 24F709863?
Yes.
Okay. All right, this was my partner's case, Your Honor. I apologize. I don't have intimate knowledge of it. I do have it pulled up, though, now.
Ms. Willingham's case?
Yes.
I would,
Would you like a bench competency?
yeah, and Ms. Willingham and Mr. Peckowski. And I'm waiting on Rob, and I'm waiting on Gatlin, and then I basically got a clear area where I can do Taylor.
That is correct.
Okay. So I have to just give that time to debate. Court's gonna stand in brief recess.
All right. You may be seated.
Okay, what can you tell me?
Came in as a felonious assault domestic violence case, where a allegation of a metal pipe was involved. There was injuries to the victim recorded as a cut under the left eye, swollen and bruised left eye, and then bruising on the chest, back, and the left leg. And the suspect was listed as Derek LaRanger in this incident.
And it's a male, Tony Anver Karen Jr., correct?
Yes, that's correct, as the victim. Yes, Your Honor.
And it all occurred at 29335 Sheiks, right?
29335 Sheiks, City of Flat Rock. Yes, Your Honor.
Do you have anything you want to say on bond, Mr. Westmoreland?
Yes, Your Honor. I would like you to know that Mr. Loringer is currently residing in Brownstown, but he is at a treatment facility. He currently does collect Social Security disability benefits, so he is on a very limited income. He did appear here today, assured me he would be appearing at all future court dates, so I just asked that all that be taken into account.
Lieutenant, he's in treatment. What is your position?
Your Honor, as long as there's no contact with the victim in this case, we leave it up to the discretion of the court.
$30,000 personal bond, Mr. Loringer. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed. No contact with Tony A. Karen Jr. or prosecution witnesses. You're not to enter 29335 Sheiks in Flat Rock. No marijuana, no alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're not to possess any firearms. You're not to possess dangerous weapons. He probably has not been fingerprinted yet, has he?
I don't believe so, Your Honor. This was an out-of-custody case.
Yes, I have been fingerprinted, Your Honor.
All right, hang on. The question isn't whether you've been fingerprinted before. The question is whether or not you were fingerprinted on this case.
I was, Your Honor.
I'm checking now, Judge.
Yeah, it looks like he was. If it was, oh, wait a minute.
I was, but then I went to the hospital. That's why I didn't see you.
Your Honor, he has been printed on this case. That's correct.
All right, so those are your court dates. You need to appear by Zoom on the first one, and then you'll have to appear in person for your preliminary exam. You are going to be in front of Judge Hessen, and that's it. Good luck. Thank you. Anything else, Mr. Westmoreland?
Not this time, Judge. Thank you.
Lieutenant?
No, Your Honor. Thank you.
Thank you.
Can you mail that information to me, Judge?
Yeah, Lisa will get the information from you. She'll put you in a breakout room and she'll speak to you, okay?
Okay, thank you, Judge.
Thanks. Daniel Burton, Daniel Anthony Burton, 22F2388838, B 23F241417, and 22F728849. I'm going to need Jessica in here on this, please. Your name?
Daniel Burton.
Counsel?
Attorney Corey Westmoreland appearing on behalf of Mr. Burton.
So really, all he did the other day, all I did was really just set bonds and he stood mute. Let's take the probation violation first on the MDOP, 200 or more, but less than 1,000. The charges are failure to pay fines and costs as ordered and failure to provide proof of attending personal counseling. How's he going to proceed on those?
Yes, Your Honor. After speaking with Mr. Burton, he understands his rights. He is prepared to waive any sort of contested hearing and enter a guilty plea.
Is that what you want to do, sir?
Yes, Your Honor.
Good morning.
Good morning, just put on behalf of probation.
All right. If you plead guilty here, since you've absconded, I want you to understand that you could get 90 days. You could get the maximum on. Actually, you could get 1 year on this. Do you understand that?
Yes, Your Honor.
All right. Yeah. You're presumed innocent. They have to prove you guilty by preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
All right. To the charge that you failed to pay your fines and costs as ordered, how do you plead?
Guilty.
Did you fail to pay your fines and costs as ordered?
Yes.
To the charge that you failed to provide proof of attending personal counseling with Aguirre, how do you plead?
Guilty.
Did you fail to do that?
Yes.
Anybody force you to do that?
No.
Plea is accepted to that, both counts. And then I've got on a failure to pay on 22F 238838B. He owes 305. How's he going to proceed on that?
Yes, Your Honor. At this time, we are prepared to enter a guilty plea for failure to pay.
Plead guilty to that, you could get 31 days. Do you understand that, sir?
Yes.
You understand all your rights that apply?
Yes.
To the charge you failed to pay 305, how do you plead?
Guilty.
Is it 305 or 205? It's 205, my mistake. Did you fail to pay?
Yes.
Anybody force you to plead guilty?
No.
And then on the charge that you failed to pay 405 on 241417, knowing that you could get 60 days, how do you plead to that?
Guilty.
Did you fail to pay?
Yes.
Anybody force you to plead guilty?
No.
Plea is accepted to failure to pay 405. So I've got him on 405, 205, and then on the probation violation. What do you have to say, Mr. Westmoreland?
Your Honor, my client's apologetic. He was actually under the impression that he was released from probation. It's my understanding that he did serve 21 days already in custody. He thought he was done after that because he hadn't heard from probation in about 3 months. So he understands that he does owe this money. He needs to get on a payment plan, and that's his goal at this time.
Anything you want to say, sir?
That seems about right. The only part that he's probably missing out is that I did end up going to a mental health treatment program at Samaritan Hospital in Detroit after receiving the probation violation letter, and I'm back on my medicine.
You are now?
Yes.
When did you go back on your medicine?
I was released in early May. And
Yeah, but you weren't, were you on your medicine the other day in front of me?
actually, no, I haven't taken my medicine. My follow-up date to receive the rest of my medication is today.
You actually seem, how do I say it? Slightly respectful today. The other day you were just like
Just a little bit upset that I wasn't informed that I wasn't on probation still, that I could have been locked up. I apologize for my actions.
Today's the 3rd, so he's been in since Friday, Saturday, Sunday, Monday, Tuesday.
And then he's completed 7 days on the court work program as well, and he also had 1 day credit served at the very beginning of his probation term as well, Your Honor.
I think I already gave him credit for those.
He completed 7 days total for court work program. You had him listed as 6, but he ended up completing 7 total
Let me
for
see.
additional jail credit days.
Okay, those were the court work program
Yes.
days that I gave him. So I already gave him credit for those, I
Okay.
believe.
And his case did expire on May 14th, Your Honor, of this year.
Yeah, I know. There's nothing I can do. How much money can you come up with, Mr. Burton?
I don't have much money today.
We have a problem then, because I can't really extend probation anymore.
Only thing I'm asking is, there was a little bit of confusion. If I would have known that I was even on probation, this was kind of new, going to jail and getting out and resuming probation was something new. Never done that before during probation. So that's why I'm asking for one more chance. I am working. Once again, I'm back doing landscaping. That's what I usually do in the summertime, around this time, spring. I'm here. I'm willing to do what I have to do. I don't have any distractions anymore. I don't have a girlfriend. I don't have a child running around in my face every single day. I've been committed to finding a job, actually another job, to pay off probations and tickets that I owe. Because it's starting to get stressful, and I'm starting to understand that I'm getting a little bit too old to be dealing with court.
So I think since he's been in custody for 5 days, he has credit for those. Why didn't you attend the personal counseling like you were supposed to?
Once again, I go back to the point where I did not understand that I was still on probation after being released from the county jail. Especially knowing that I didn't have a single phone call or I didn't have any extremities in there. I bare knuckled that county time. I couldn't do anything. I missed meals even. I stayed even extra days that I was in because the system was down. I know it's not your fault, it's not my fault, but I am here and I am trying to be responsible for my actions.
Judge, I never got any report from the therapist when the last time he was scheduled for an appointment or anything like that. They were difficult to contact always. I usually always had to reach out to them. I reached out to them back in November, never heard anything from them since, Your Honor. So I don't know when he stopped going or when the last appointment even was, because they haven't reached out to me.
So I stopped going after I got out of jail. And then you guys sent me a letter in the mail saying that I violated probation. And then once I got the letter that I violated probation, I actually took myself into a hospital to get put back on medicine. I've been on medicine ever since.
And that is concerning that it's good that he's back on his meds. That was a concern for a long time.
All right. I'm gonna revoke your probation on 22F728849. You have served 21 days, credit 21. I'm closing that case. I'm gonna let, on the speeding, Lisa, 838B, I'm gonna give him credit for time served the last 5 days and close the case. On 241417, he's going to have to pay 405 or serve 5 days, credit 5. I'm closing all these cases. Next time, be a little nicer, will you?
All right, Ms. Ramos, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.